Morning.
Good morning.
Good morning.
Okay, I see that we have a court reporter. So for her benefit, I'm going to go ahead and call the case and get us on the record. Madam Court Reporter, this is going to be a hearing, actually a evidentiary hearing in the matter of Praveen Chanda versus the Fulton County School District et al. Case number 25CV001199. If I could have announcements for the record from counsel, starting with counsel for the petitioner.
Randy Waldman, Barton Juvenile Defender Clinic, on behalf of Praveen Chanda and SC.
And for the respondent?
Bennett Bryan, and I'm joined by Ashley Akins for respondents in this case.
Okay, excellent.
Sorry, and I'm joined by Mariah Windis.
Thank you. Appreciate that. So let's start with today was set for an evidentiary hearing on the substance of this matter. And this morning I have received a motion to quash filed by the respondents regarding subpoenas for attendance today at the Zoom hearing on three of the principals identified. I believe it is, let's see, Dr. Looney, COO Noel Maloof. I don't know if it's Noel or Noel, and the principal of Innovation Academy, Scott Kent, on the grounds that those subpoenas were not served properly. I have had a chance to read your motion, Mr. Bryan, and so I'm going to ask Ms. Waldman to briefly respond and see where we are on this issue, and then we'll go from there. Ms. Waldman.
Yes, I will note for the record that I received a copy of that motion roughly 30 minutes ago. I have
About the same time I got it, so
that's very little time to read the motion, much less formulate an appropriate response to it. I will note that I perhaps mistakenly understood Mr. Bryan to have accepted service. We had talked about subpoenas. He had talked about filing a motion to quash with respect to substance that I was prepared to respond to and remain prepared to respond to. I did not understand him to have a procedural objection. Perhaps that was a misunderstanding during our phone conversations. I do have returns of service, at least as to, and quite frankly, I just didn't check my mailbox at all this week because it is in a different building, but I do have returns of service with respect to Noel Maloof and Scott Kent. I have not checked to see if I have a return of certified mail service with respect to Mr. Looney. As I mentioned, my mailbox is in a different building, and I did not know this was going to be an issue for me to search for it this morning. To the extent that Your Honor finds that service was not perfected, we would love to address the substantive issue with respect to the appropriateness of the subpoenas, and then would respectfully request a week reset to perfect service. Honestly, this matter had been on the calendar for a very long time. We reset this motion from last Friday, serving me with this motion at 8:30 this morning. Was a little bit, I'd say, disingenuous on behalf of respondents.
thank you, Ms. Waldman. Mr. Bryan, as I said, I have read your motion, so I don't need you to completely go back and re-argue it. As I'm going to say what I think I understand it to be, and then you can respond to Ms. Waldman and let me know if you disagree. As I understand it, your position is primarily a lack of proper service, either that you were not authorized to accept service and service on you by email is not a proper form of service of a subpoena of those clients, or that Ms. Waldman doesn't have proof of service for purposes of certified mailing service, although I believe I understood her to just now represent that she does believe she has proof as to Maloof and Kent, but perhaps not to Dr. Looney. Secondarily, I believe I understood your motion, Mr. Bryan, to be talking a little bit more about the actual knowledge that those individuals might have in terms of the relevance of their testimony to this proceeding.
Yes, Your Honor. I think that adequately sums it up there. I would like to just quick note, it's pretty clear under Georgia law, both under Georgia statutory law and under Georgia case law, that uh, subpoenas may be objected to. I mean, even during trial, when the witness is called, so we've got several Court of Appeals opinions saying that there is no duty to file it far in advance. You can actually object at trial. I wanted to make sure that we at least had some sort of motion, some sort of papers on the record to see the argument instead of doing it entirely orally. But under Georgia law, it would even be fine to just bring this up as an oral objection. Otherwise, as far as the service issue is concerned, I mean, it's pretty clear the Georgia Supreme Court said email is not a proper means of serving a subpoena under OCGA 241324. That's easy. So any service through email is not enough. Now, service without valid proof of return receipt from certified mail is also problematic and results in an unenforceable subpoena. We have a couple of Georgia Court of Appeals opinions, saying for example, without Graham v. Newsom, which is all this is cited in the brief, without offer of proof showing service by a return receipt of registered or certified mail, the trial court cannot enforce a subpoena.
Right, but Ms. Waldman has just represented that she's got proof of service of certified mail return receipt, at least as to Maloof and Kent. And she says she might have it as to Looney, but she hasn't been to her mailbox to figure it out. So,
I mean, fair enough, Your Honor. I mean, she did say that. A, that is not in the record. But B, the affidavits of both Maloof and Kent specifically say that they never signed any return receipt, and the United States Postal Service employee never handed them any certified mail or any subpoena. So I highly doubt that she has a return receipt with their signatures on it. And under, longstanding case law, sort of leaving a subpoena at someone's workplace in like a mailroom or with a clerk or someone like that is insufficient service of process. So let's just say hypothetically, I'll say that assuming that Ms. Waldman does have certified mail receipts, signed ones from from a service of a certified mail, they're not going to be the signatures of the witnesses. And so it's that alone is insufficient to render a subpoena valid. And that's all cited in the briefs, the Haywood case, the Edenfield case, the Apoyan case. In all of those cases, they say that, hey, like a subpoena must be served on the individual to whom it was directed. Obviously, there's one exception to that, and that's counsel. If counsel is properly served by one of the methods in the statute, but it's pretty clear that it must be served on the individual to whom it was directed. In Edenfield, a process server or a sheriff's deputy served a subpoena to the clerk at a state trooper's patrol station, and then that clerk put it in the trooper's mailbox. Court said, no, that is improper service. The subpoena is unenforceable. And then in O'Payne versus State, which again is cited in the brief, in that situation, an attorney served a subpoena on a representative at the Atlanta Police Department, and a representative at the Atlanta Police Department signed the receipt of service. And then when the officer didn't show up for the hearing and didn't testify, he was held in contempt. And the Georgia Court of Appeals reversed that, saying that the subpoena was not enforceable because even assuming it was signed by somebody, it wasn't signed by it wasn't placed in the hands of the officer himself through a method that was approved for service. And, service statutes are strictly construed, and they're compliance with service statutes is strict. There are plenty of cases saying that it doesn't even matter if there's evidence in the record that the witness actually has the subpoena in hand. If it wasn't served properly, then then it's unenforceable. And then finally, there's another issue here, is that there's a failure to include a witness fee. Now, Noel Maloof lives outside of Fulton County, and under OCGA 241325, it specifically says that service must be for anyone that lives outside of the county from which they're being summoned. A witness fee must be tendered along with the subpoena itself. And Georgia Court of Appeals and Williams v. Russo, which is cited in our brief, service of a subpoena upon a witness who resides outside of the county in which he or she is being summoned is only valid when it is accompanied by tender of the fee for 1 day's attendance. Now, those are the service issues. Those are our primary arguments about the service issues, and I think all of them, they're both colorable and correct. Now, the other issue that you mentioned, Your Honor, is this is sort of a more reasonableness standard. The service issue is pretty much a pure question of law, but we agree that the quashal for being unreasonable or oppressive, that one is committed to your discretion. And generally, in those circumstances, we would say that this makes sense that it's unreasonable and oppressive if Dr. Looney specifically, submitted an affidavit, said that he wasn't involved at all in the underlying facts of this case. He had no personal involvement in it, and he has no personal knowledge of it. He did not participate in the decision to deny SC's application to Innovation Academy or for her change of school assignment. He just was not involved at all, and so calling three high-level officials, I mean, the CEO, the COO, and a school principal for, a sort of routine, daily administration of a school system, a single student's request to change schools, I think that is unreasonable to subject those officials to trial and to testifying, especially in a situation where the highest level executive official doesn't have any personal knowledge of it. So those are generally those are our arguments. I understand that you've read the briefs, and I do appreciate that. And so we would ask you to quash it. Now, as far as what Ms. Waldman had stated about, we did talk pretty much as soon as I got that email about the subpoenas. I called Ms. Waldman right away, and I said, hey, look, Dr. Looney doesn't know anything. If you're willing to withdraw Dr. Looney's subpoena, then we won't object to the subpoenas. And, that offer was rejected. That offer still stands. We'll go ahead. If she withdraws her subpoenas, or at least if she withdraws Dr. Looney's subpoena, then we will withdraw our objections to Noel's, or to Mr. Maloof's and Mr. Kent's subpoena. But if not, then we would ask you to quash all three of them.
Ms. Waldman, you willing to accept Mr. Bryan's offer?
I remain unwilling to accept Mr. Bryan's offer. As that conversation with Mr. Bryan entailed, we have 13 respondents in this case, and very considerably, consciously thought about who we needed to prove our case. Mr. Bryan continues to allege that this case is about a student assignment decision that's made by the school district.
I understand the different characterizations.
It is not.
Bryan wants to characterize it as,
right,
a decision by the school not to accept placement of a student into a specialized program. Obviously, your position is the refusal of the school district to reinstate a student who was never disciplined. I understand, and we don't have to get back into that now. Go ahead.
And Dr. Looney has what I believe to be critical evidence to that decision. Now, if Mr. Bryan will we can continue with our horse trading. If Mr. Bryan will stipulate to the proposed exhibits that we sent, we will not need the actual testimony of Mr. Looney. But he has rejected that offer. And so I need either the exhibits or Mr. Looney's testimony as to those exhibits in order to refute some of the claims that Mr. Bryan has brought up on behalf of his clients in his briefing.
Okay. Thank you, Ms. Waldman. So let me back up for a few minutes and say this. I quibble a little bit, Mr. Bryan, with your reliance on Smith versus State about the service of a subpoena by email. You're not wrong that I can't serve a subpoena on a witness by emailing that subpoena to them. But it's pretty well established, or else the legal system would come to a screeching halt pretty quickly, that we lawyers can email things back and forth to one another all the time. Now, certainly Ms. Waldman's emailing of those subpoenas to you is not service on those witnesses, but it was certainly an effort to secure their presence here today by waiver, acknowledgement, or whatever we want to call it. As to the issue of proper service, I also quibble, Mr. Bryan, and it's not just you. I run into this issue frequently with witnesses, particularly high-level witnesses who are in large organizations. And when I read a brief that says, you didn't serve the COO of Fulton County School Districts at their home, I frequently get very frustrated with that argument, because if they had gone and served that person at their home, most of the time people would be screaming with their hair on fire that they were harassing that person whose testimony was clearly only being sought in a professional capacity. And given the high level of such officials, I also run into the issue where it is very difficult to place a subpoena in their hands, particularly where service by certified mail is allowed. And so I'm not sure that I agree with the strictures of your argument, specifically in terms of the need to quash the subpoenas, particularly as to Maloof and Kent, except to the extent that apparently one of them lives in Fulton County. It is frustrating to me that, given that the purpose of today's hearing was to get into the substance, it is frustrating to me that we are still having procedural disputes regarding getting to the substance of this matter. And so I'm a little frustrated by that. Having said that, I don't know that Mr. Bryan is entirely wrong about the particulars that he's asserted about the motion to quash. Particularly to the extent that it's, somebody is I'm sorry, Mr. Bryan, who did you say was outside of Fulton County and didn't receive a fee check?
Mr. Maloof.
Mr. Maloof. And I assume, and again, I'm not sure I agree that the signature on the return receipt is required to be the signature of the individual subpoenaed witness, particularly in a large scale organization where their testimony is being sought in a professional capacity. However, if we're going to cross every T and dot every I, then, Ms. Waldman's request was to reset this matter for a week until she can get everybody served. Or we could, I'm trying to find a way to make today not a complete loss. We could go forward with Maloof and Kent. And then perhaps allow some additional time to secure service on Looney. I understand the parties' very divergent theories of the case in terms of whether or not Dr. Looney would have relevant testimony. But as I understand the briefing, I would assume that Ms. Waldman's point is that Looney would have knowledge of the Fulton County processes and procedures on which she relies to make the argument about due process and other matters. And so that's why I'm assuming she's saying that he does have relevant information, even if he doesn't have specific factual information about this particular the handling of this particular student's requests, discipline, admission, or rejection.
May I chime in, Your Honor?
Yes, Mr. Bryan.
Just for background, the chief operations officer leads the student assignment committee. So to the extent that there's any discussions about the procedures that would be involved here, if, because it sounds like to me, Your Honor, you're considering can we move forward with Maloof and Kent and see what happens there, right? And in that situation, if we're talking about the procedures, as you mentioned, that apply to this case, that apply to a change of school assignment, the student assignment committee, and the decision of whether to re-enroll SC at Innovation Academy, that is exactly what Dr. Looney has no knowledge of, and that's exactly what Mr. Maloof does have knowledge of. I mean, it's right in the board policy. It says the student assignment committee is led by the chief operations officer.
I understand that, but again, Mr. Bryan, I think that goes back to the parties' divergent characterizations of the case. I completely agree with you, and I suspect that only Maloof would have any knowledge of this student or of the policies and procedures associated with assignment to the school. But as I understand the briefing that's been submitted on behalf of the petitioner, there is a larger argument they wish to make about procedural due process and property interests that the superintendent of the schools, I think I understand, I'm assuming Ms. Waldman's argument would be, is uniquely qualified and positioned to respond to those issues. Um, so what I think I would like to do, if it's possible, is to go forward to some extent so that today is not a total loss, potentially with Maloof and Kent. But Ms. Waldman, if it is your preference that we back up and secure proper service on Looney so that you can present your case in the way that you wish to present your case, tell me that now.
I'm happy to go forward with the testimony of Maloof and Kent today. I did just send my law student to our mailbox in a different building to see if there is a return receipt in there.
Okay.
We might have that answer.
Okay.
It's about 5-ish minutes.
Thank you, Ms. Waldman. I think what I'm going to do for temporarily is find that certified mail service to the extent that Ms. Waldman has represented to the court as an officer. And we are on the record. I don't have, admittedly, the signed return receipts, and I don't believe she's representing that they are individually signed by Maloof or by Kent. The record will reflect that Ms. Waldman is holding up the green square signed return receipts. I believe that is sufficient to demonstrate that service was accomplished through certified mail of these subpoenas to Maloof and Kent, particularly in the context that they are being called to testify in their professional capacities on behalf of the Fulton County School District. And so that's going to be my ruling, and I think we can go forward with them, and perhaps I'll make a similar ruling if and when Ms. Waldman provides evidence of a similar return receipt relative to Dr. Looney. Any other procedural matters that we need to address before we attempt to get started substantively, Ms. Waldman?
Yes, Your Honor, I do think there are some procedural matters with respect to exhibits. Some of it good news. The parties have stipulated to the introduction into evidence of petitioners' exhibits C, D, E, F, G, P, Q, and R.
Okay.
We have stipulated to the introduction into evidence of respondents' exhibit A.
Hang on, sorry. I'm trying to take notes. Response A, go ahead.
Those are the stipulations. I would ask the court to take judicial notice of petitioner's exhibit A.
Isn't that my order?
That is your order.
That's what I thought. Mr. Bryan, if you have a strong objection to my taking judicial notice of an order that I wrote, that I entered and edited, that is part of my docket in this case, tell me now. But otherwise, yes, I would be inclined to take judicial notice of Exhibit A.
As far as judicial notice goes, Your Honor, I mean, we agree that courts can take judicial notice of court records and other papers filed, especially in your own courtroom. In fact, we actually previously in our motion for summary judgment asked you to take judicial notice of all the documents in that case as is. I think that this raises a little bit of a different issue, which is, of course, we agree, we stipulate that that SC's discipline was reversed. We stipulate that she was charged with a violation of the student code of conduct. She was disciplined. She was successful in her appeal in getting that reversed. And so at this point, I don't really see the relevance of that anymore. As far as
Right, but relevance isn't, I mean, relevance is a basis to object to admission at the time of its admission, right? But it's not generally, unless it's wildly irrelevant, it's not generally a basis to object to judicial notice. I mean, if when she wants to talk about it, you could say it's not relevant to anything that we're doing right now. That's one thing, but I mean, it is a record of this court. It is a record of this court involving issues between two parties. And if at the time that Ms. Waldman wants to reference it, I mean, I don't disagree with you that a lot of what's covered there is well established and not really in dispute in this case in terms of the outcome of the prior case. And I understand the school district's position regarding the court's prior ruling and what it addressed and didn't address in terms of for res judicata arguments, et cetera. But for now, I'm going to take judicial notice of my own order, which is petitioner's exhibit, proposed exhibit A. Go ahead, Ms. Waldman. I'm sorry. Did you have something else to add, Mr. Bryan?
No, Your Honor, that's fine. I'll just wait on those arguments for later. I do not disagree with you that you have every right to take judicial notice of that order.
Okay, thank you, Mr. Bryan. Ms. Waldman?
One final procedural question is with respect to SC herself. She does intend on testifying at today's proceeding. Just for clarification purposes, for anonymity purposes, we have been referring to her as SC. When she introduces herself, may she do that as SC? Does she have to state her full name? May she stay off camera? Some of those logistics questions that I just honestly don't know how work in Zoom world and streaming.
I'm fine with that. Mr. Bryan, if you, I feel like there's a couple of ways we could handle this. One is what Ms. Waldman is proposing, which is as long as everyone is satisfied that SC is the person who would be in whatever blacked out box that would appear on the Zoom screen to your satisfaction, that we could allow that person to testify as SC and to testify without being physically on screen. The other option, given that SC is a minor, I believe that the court has the discretion, if I chose, to close the courtroom for a limited purpose. And so, for example, if the school district required that SC be physically visible on the camera and testify in that manner, I could direct that the live stream be taken down for that portion of the testimony, and the portion of the testimony, the portion of the transcript where that testimony is occurring, be sealed. Those are options that we have. Personally, I think the most workable option, if you're comfortable with it, Mr. Bryan, and are satisfied that the person testifying is in fact SC, is to allow SC to testify as SC from a black screen. But if you feel the need to see her for any number of reasons, which are, I don't mean to imply are not legitimate concerns that you might have, then we can do it the other way. What are your thoughts, Mr. Bryan?
Your Honor, can I request 2 minutes to give my co-counsel a call real quick here, and I will be back with you in just a minute.
Certainly. The only other thing I'll add, Ms. Waldman, is that I would want some assurances that SC was in a room alone and that no one was there assisting her with testimony, that there was nothing open on the screen, just some general reassurances that we would ask for to assure that it's as akin to testimony in a live courtroom as we can make it.
Understood. I do know that she is in the room with her dad.
Mm-hmm.
But we could, I don't know how you feel about that, but we can make any other assurances.
Okay. Mr. Bryan, just to add that point, if you want to take a moment to consult with Ms. Akins, feel free. I'm going to go grab some more coffee while you do that. We'll all be back in about 3 minutes.
Sounds good. Thank you, Your Honor. Your Honor, I think that I think we could deal with this one of two ways. Uh, Either A, she testifies with a blacked out screen as SC, as long as there's no one else in the room with her, and as long as there is someone sort of outside the room, that confirming that no one is in the room with her. Otherwise, if we can't have that, then we'd prefer that she be on camera to make sure that she's not getting any cues from her father or from anybody else at that point.
Okay, it feels like Ms. Waldman is willing and comfortable in offering those assurances. Is that correct, Ms. Waldman?
That's correct.
Okay, then that's what we'll try to do. If there's any concerns, once that testimony gets underway, which as the parent of children approximately this age, I feel like it'd be pretty obvious if a 17-year-old was being coached, but maybe it won't be. Who knows? But if you do have concerns, Mr. Bryan, as we begin that process, you can raise them, and we will we'll take appropriate steps to provide reassurances if there are any concerns. But for now, I appreciate y'all's willingness to agree to a potential workable resolution for that. Anything else, Ms. Waldman, procedural before we get started?
That's all I had, Your Honor.
Mr. Bryan, how about you?
Well, I guess, and maybe this is more appropriate to bring up later, but I thought that maybe it could be addressed ahead of time, is just figuring out exactly, in your view, Your Honor, what you believe the scope is of whatever it is. Is there any is everything fair game in terms of the previous student discipline proceeding? Obviously, it's our position that relitigating any issues that were, any claims and issues that were brought up there now, legally irrelevant and inadmissible. And maybe the better thing for me to do is to just object during the hearing itself. And if that's how we want to handle it, that's fine. But I was just curious if the court had any direction there because since we didn't get an order, it's a little bit unclear. But it's not uncommon for folks to object to evidence or file motions in limine to prohibit the evidence that would be legally barred by res judicata anyways. And I'm just curious if you have any direction on that to minimize disruptions during the hearing.
Couple of things. Number one, to your substantive point, I think your point is valid, and I've already said that. I don't know that it merits anybody's time rehashing the issue of the alleged wrong for which SC was disciplined, which has been all of that effectively wiped away, right? We understand that. I think, however, that it would be difficult for me to say as a general matter, we're not going to talk about that at all, because I suspect that, as we've talked about at various different times, some of that background may be necessary and relevant. And so what I will say is, as a general guide, I don't think that it's a valuable use of anybody's time to go backwards and talk about the ins and outs of the disciplinary process or the procedural outcome of that disciplinary process once it was litigated through the Superior Court. But you also have the right to object on relevance or any other grounds if Ms. Waldman feels like she needs to go down that road. The second question I do have is a procedural one. Mr. Bennett and Mr. Bryan, you just mentioned something about since you don't have an order, and your trial brief also mentioned that you don't have an order, but I entered an order denying your motion to dismiss and your motion for summary judgment on March the 31st. It's docket number 33 in my file. And so I don't know what happened. I don't know if y'all weren't served with it, which is a problem that sometimes happens, but y'all are definitely service contacts and have received notice of everything else. I'm happy to have Mr. Freehoff email it to you both, Mr. Bryan and Ms. Akins. But I noted that in your trial brief as well and thought, oh my Lord, did I forget to enter this order? And then I went back and looked at it. There it is.
I can say I mean, obviously I wouldn't have put that in there if I'd been served with it.
No, I completely understand.
I don't know what happened. Ashley, did you receive that?
I did not, and I recall looking through the online filing system and couldn't find it, but we're going to look again, obviously. But no, I never received.
In the interim, Mr. Freehoff is on this Zoom, and while we are sitting here talking, I'm going to have Mr. Freehoff email you a copy of that entered order and see if he can find out if there was some issue with your service, because sadly that does sometimes happen, that people who are listed as service contacts, when we hit file, it's supposed to serve everyone that's listed as a service contact, but sometimes the e-file Georgia system isn't perfect. I know you might be surprised to know that, but in any event, we'll make sure that you have it. And obviously, although I denied the motion to dismiss and I denied the motion for summary judgment, I don't know that it is dispositive of the outcome of today's hearing, because that's part of your whole argument. I mean, legally, yes, I've made some rulings that I talked about at the hearing in terms of that I was not persuaded by some of the legal arguments, but the factual arguments that underlie those certainly I think are still fair game. So, okay.
Well, I guess we'll be doing some on-the-fly analysis here.
Yes.
But in any event, okay. So what I understand you to say, Your Honor, is that this topic is probably better suited for specific objections to evidence at trial.
That's correct. With the caveat that I'm advising everyone, if there's a specific reason you think you need to go into some aspect of the prior procedural history and factual history, then tell me what it is. But otherwise, I don't know that it serves our purposes to go into it a whole lot, since we all know what happened and it's largely undisputed. Anything else, Mr. Bryan, before we get started?
No, Your Honor.
Ms. Waldman, do you want to make argument or do you want to start by calling a witness?
I would like to make a brief opening, Your
Okay.
Honor.
Go ahead.
Yes, Your Honor. Good morning. The only question before the court today is whether a student who's removed from her school has the right to return to that school once her discipline is overturned and her removal is deemed illegal, arbitrary, and capricious. This is a simple question with an easy answer. Respondents have inappropriately recategorized this to be a case about school choice and discretionary decisions schools get to make when a student applies to a specialized school. Their argument would be correct if SC had never been accepted to Innovation Academy, never enrolled in Innovation Academy, never been illegally removed from Innovation Academy. But, as we will demonstrate through the hearing today, SC did appropriately apply to Innovation Academy as a 9th grade student. SC did experience the specialized instruction and environment at Innovation Academy while attending the school for the first semester of her 10th grade year. SC did obtain an expectation that she would only be removed from Innovation Academy for cause. That expectation was violated. Thus, rather than being about school choice, this case is about the appropriate remedy when a district acts illegally, arbitrarily, and capriciously. A century's worth of law over a multitude of scenarios tells us that the appropriate remedy for an illegal deprivation of a right is to return the person to the position they would have been in but for that deprivation. This isn't novel. This isn't complicated. This is common sense. Any result other than returning SC to her rightful place at Innovation Academy turns due process into a sham, which is exactly what has happened to SC. In the world proposed by respondents, any student could be removed from any choice school for any reason at any time. On Mondays, Innovation Academy could arbitrarily remove students who wore red. On Tuesdays, gray backpacks. Wednesdays, plastic water bottles. And on and on and on. Each removal could be deemed illegal, arbitrary, and capricious. And yet in the end, the district would be insulated from any consequences. Thankfully, that's not the world we are living in. The clear dictates of due process and state and federal law require students who are illegally removed from a choice school be returned to their rightful place in that classroom. Thank you.
Thank you, Ms. Waldman. Mr. Bryan, do you wish to make an opening statement?
Yes, Your Honor.
Okay.
I'll make it quick. This case is about whether, okay, so this case is supposedly a due process case. Supposedly, SC has a due process right to be re-enrolled at Innovation Academy after a 1.5 year break in enrollment. But we have to ask, what does due process require? Yeah, if due process is the source of SC, the petitioner's right in this case, then we have to ask, what does due process require in the first place? And due process requires a full and fair opportunity for a claim to be heard. That's it. Okay, we have plenty of 11th Circuit, Supreme Court case law. If we're talking about federal due process, a full and fair opportunity to litigate their claims to relief through an administrative hearing. I'll get into later, after evidence closes and we get to the directed verdict and closing argument stage, I'll flesh that out a little bit more. But she has to prove that she had no full and fair opportunity to litigate her, to litigate her right for re-enrollment to Innovation Academy. And she absolutely had a full and fair opportunity to do that throughout all of her hearings and throughout through all the proceedings in Superior Court. And to the extent that it is SC's or that it is the court's position and the petitioner's position that this case does not arise from the denial of her application for Innovation Academy. And really, this case arises from a due process right that to continue attending Innovation Academy. And I will point to page 6 on the petitioner's brief in support, where it says SC's property interest in attending Innovation Academy was created when she was validly accepted and enrolled in the school. And this same property right has been continuously denied since SC was illegally suspended in February of 2024. This shows that the right accrued to the extent that she had one back in February of 2024. I will not rehash all the res judicata arguments here, but for now, we maintain that res judicata bars this action. But let's get briefly into the mandamus standard, which says that you have to show a clear legal right to relief and no adequate legal remedy. Of course, to the extent that this claim arises under the federal due process clause under the federal constitution, mandamus is not the proper vehicle to vindicate a violation of federal rights. That is 42 USC section 1983. She has an adequate remedy there. Second, mandamus is not the proper vehicle to challenge the constitutionality of a local ordinance or policy. All right.
Is it just, I mean, obviously it's just an opening, but I understand, obviously there's the potential for a 1983 action anytime someone is arguing that a federal law has been violated, et cetera. But I mean, the purpose of mandamus is to force a government official to undertake a duty that they're obligated to undertake, right? To perform some government function. And I understand part of your argument is that the government here doesn't have a clear legal obligation to perform the obligation that they're seeking to compel. But does the fact that there is potentially a claim for damages or something like that, does it negate the possibility that one could pursue procedural relief in the form of a mandamus saying, hey, school district, do this thing that I argue you're legally obligated to do?
It is our position that 42 USC 1983 is an adequate remedy at law, and mandamus is only available if there is no adequate legal remedy. And of course, injunctive relief is one of the forms of relief under 42 USC 1983. But in any event, what we have here, and the evidence will show that when a student has a break in enrollment for any reason from a school that is outside their attendance zone, they must reapply for entry for readmission to that school through the student assignment committee. The board policy specifically says that a student is only eligible for a change of school assignment if there is room in the school. And if the school if the school is only at 95% capacity, and definitely not if it's over 100% capacity. And so we have a policy that my clients followed to the T, and there is no legal challenge to this policy. There can be no legal challenge to this policy through a mandamus action. The site for that is Carson v. Brown, 348 Georgia App 689. And in that case, the Court of Appeals said you cannot use the vehicle of mandamus to attack a local policy. That is not the purpose of mandamus, or you cannot use it to attack the constitutionality of a local policy. So the policy that is currently in place required my clients to do exactly what they do, and they complied with it. And there can be no challenge to that policy. There can be no constitutional challenge to that policy through this mandamus action. So she will not be able to show that she has a clear legal right to relief because the policy itself shows that she has no clear legal right to relief. And
what subsection, or when you're talking about the policy and you're talking about the break-in enrollment, can you tell me what document and what portion of that document you're referencing?
Yes, it is Defense Exhibit It is Defense Exhibit A. It's our only policy, or it's our only exhibit. And if you scroll down to subsection 11, says schools without attendance boundaries. Students with a break of enrollment for any reason must reapply for admission. These applications will be reviewed by the school assignment committee. And then if you go back up to subsection 1, it explains when these applications should be approved. And it says, only if there is space. Schools must have available permanent learning space and capacity, and they have to have enrollment of 95% or below of their stated capacity. All right. And so that is a policy in effect, and it was in effect as of August 1st, 2024. And that is, my clients complied with that to the T, and therefore she does not have a clear legal right to relief in light of this policy. Also, they've raised another argument that there was some sort of abuse of discretion here, right? Because in fairness, the mandamus standard says, look, you have to show a clear legal right to relief, or you can show a clear abuse of discretion. Now, it's unclear exactly what decision they're saying was a abuse of discretion, but from the opening, it's hard to tell. From their brief, it's not hard to tell at all. It says page 18 of their hearing brief says respondents acted in an entirely arbitrary and capricious manner in removing SC from Innovation Academy without evidence of wrongdoing. Well, of course, when they did that, that was the discipline decision. So she, again, the only allegation that she's made that there was some sort of abuse of discretion was the decision to remove her in the first place. That is clearly barred by res judicata, Your Honor. They already challenged the wisdom and the lawfulness of that initial disciplinary decision, and they do not challenge as arbitrary and capricious the subsequent decision to deny her re-enrollment based on her change of school assignment application to Innovation Academy. And so she has a very, 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 very tall burden here to prove, A, that there was a property right at all. There was no property right, and she will not be able to prove that there's a property right. She cannot show that the mandamus is the only adequate legal remedy. She cannot show that mandamus is the proper vehicle to challenge the board's policies. And she cannot show that there was any violation of due process whatsoever. And so for those reasons, as the evidence will show, at the end of this hearing, we will ask you for a judgment in respondent's favor.
Thank you, Mr. Bryan. Ms. Waldman, you may call your first witness.
Paul Scott Kent, please.
Your Honor, I'm going to go ahead and call him and ask him to join the Zoom meeting.
Okay, thank you. And to the extent you have other witnesses, I think Mr. Freehoff has the ability to put them in a breakout room if it makes it easier for them to just be logged on and attached, and we'll bring them in when we're ready.
And again, Your Honor, SC, I questioned, she is here. She did log on a separate device rather than with her dad, just so that we could be ready for that. I believe as the petitioner, she has the right to remain, but I defer to your discretion on whether she gets to remain for their testimony.
So to the extent that her father, she is the real party in interest, I agree with you that she is entitled to be present. And Mr. The father, as the named adult party, also has the right to be present. Mr. Bryan, any concerns or objections you wish to place on the record regarding that issue?
I am sorry, Your Honor. I was calling the witness to get him ready, so I missed that. I apologize.
No, that's okay. Ms. Waldman was just pointing out that she had placed that SC is physically present in this Zoom, although they're on two separate devices. And she had indicated that her belief that because SC is the real party in interest here, that she's entitled to be present and observe the proceedings and doesn't need to be sequestered. I agree with that assessment. I just wanted to find out if you had any concern or objection that you wanted to place on the record regarding that issue.
I'll just object and say that I believe, her father is representing her interests here, and that should be sufficient. But I also understand that you're going to overrule that objection anyways, but just put it on the record.
Yes, sir. Thank you, Mr. Bryan. Okay, so Ms. Waldman, it appears that we have Mr. Kent here. And so, Mr. Kent, will you please, thank you, unmute. And I'm going to ask you to raise your right hand. Do you swear the testimony that you're about to give the court will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, sir. You may lower your hand. Go ahead, Ms. Waldman.
Mr. Kent, please state your name for the record.
Scott Kent
And where do you currently work?
at FCS Innovation Academy,
What is your title there?
the principal of the school.
How long have you been the principal of Innovation Academy?
Going on my third year, 3 years in May.
And what are your job responsibilities as principal?
Day-to-day operations, managing the instructional mission of the school, and working with students.
And just briefly, where did you work before you were at Innovation Academy?
I was a teacher for 17 years down at Centennial High School, down in Roswell, and then an assistant principal at Riverwood International Charter School for 3 years, and then came up to IA as the curriculum assistant principal.
When did you join IA as the curriculum assistant principal?
It's what we call year zero, so 2020, 2021 school year.
And you call it year zero, why?
Oh, sorry. That was the year without students. So it was when we were planning the building, what the curriculum was going to be.
So you've been with Innovation Academy since its inception?
Yes.
And when did you become principal?
In May of 2022, I believe.
You identified in describing your role that one of your roles is to implement the mission of this school. What is that mission?
So we're a STEM magnet school. So the goal is to create authentic learning opportunities for students to be successful in STEM fields.
We've talked about Innovation Academy being a STEM school. It is also a magnet school, is that correct?
I think that the terminology is shifting with new board policy, but effectively, yes, we're a school without an attendance zone.
What does it mean to be, in your mind, a STEM school without an attendance zone?
So we're a school that anyone in North Fulton County can choose to attend, can apply to attend. We have a very clear focus in the STEM fields, the engineering, IT, and healthcare specifically as career pathways in the building. The goal is to give them a shared experience around the STEM fields and to give them, we focus a lot on authentic learning in those areas.
What do you mean by authentic learning?
So we have unique programming where students are partnered with business partners. We do long-term projects where students are engaged in project-based learning that goes outside of the classroom. It's a 4-year program where we start freshman year and we work to their senior year with very specific programming around those career pathways, research, and then connecting all of the core subjects to the pathways as well.
Okay, and what are your pathways?
So the pathway clusters are IT, engineering, and healthcare. And then there are specific pathways within each of those.
Okay, and describe what it means to be within a pathway.
Sure. So a pathway is there's a couple parts of it. In the strictest definition is a series of 3 courses that are offered in succession: freshman year, sophomore year, and junior year. But then for us, those pathways, we do Flex Fridays, which are alternative learning days where students aren't in a traditional classroom, and students are working in their pathway with business and community partners to do deep dives in those areas.
Okay, and I think you've touched on some of these, but I'm gonna maybe ask specifics about some of the particulars. You have something called a GT block, is that correct?
Yes, that's correct.
What is the GT block?
GT block is a class all students take is their freshman year. It's a combination of 3 classes. They get embedded credit for 3 classes, the introductory level class for each of the pathways.
You mentioned something called Flex Fridays. Can you describe that a little bit more?
Sure. So Flex Fridays are every Friday at our school. Roughly 2/3 of the community is at home working on asynchronous work. And then the students within one of our 3 pathways come on campus and they do more workshop convention-like experiences where they might be working with business partners or some of our teachers, but just doing a deeper dive and you know, an aspect of that career pathway that is not as academically driven.
And then you've mentioned that it culminates in the 11th grade year with I don't believe you've said the word yet, but is that the Pinnacle Project?
Yes.
Can you describe that a little more?
Yes. So the Pinnacle Project is a class that our students take. Well, so it is a project that our students do. They do that in a research class, either AP research or scientific research, which they try to solve some, you know, real world problem typically associated with their pathway. And that is taken their junior year. So all students are required to take that their junior
year. Would you consider these 3 things that I just talked about, the Pinnacle Project, the GT block, the Flex Fridays, and the pathways in general, would you consider that to be unique to Innovation Academy's learning?
There are other schools, there are other STEM schools that have similar programming, but yes, I would say it's fairly unique to IA.
When you say other STEM schools that have that programming, are you talking about STEM schools in North Fulton County?
No.
So is it unique to North Fulton County?
I think the combination of them, other schools have those, you know, have different pathways, career pathways. The Flex Friday is certainly unique to IA, but and then the research, I'm not actually sure how many schools have that as an option.
Does Innovation Academy also afford the opportunity for its students to participate in internships?
We do.
How do you work to assist students with internship opportunities?
We work very hard to develop business partners in our community or all throughout North Fulton, so our students can participate with that. We also work with the districts for a lot of those internships. They're TAG. There's really two versions of internships. We call TAG internship, which is the Talented and Gifted program, and then the work-based learning, which is through the career tech department. So we have people that work in both of those fields to try to facilitate those connections for our students.
And you mentioned that you have partnerships. Can you describe some of those partnerships?
Yes, they vary greatly, but you know, partnerships with communities or businesses in the area, you know, to who come in. GMC Networks is an architectural firm that helps support some of our programming where they'll work with our kids individually on those Flex Fridays. Just as one example.
Are there other examples?
There are a lot that in multiple different facets from companies that provide internship opportunities or will come in and you know, engage in a you know, a school-wide project we might have, like we worked with United Way for a school-wide project called Project Week, which was when the whole school tried to deal with food scarcity in their classes. So it would be hard to give you a good sampling of those. There's just a lot with a lot of different levels of engagement.
Do you have a partnership with Georgia Tech?
Not an official, so we work with their seismic program, which is their STEM outreach program. And we have a relationship with them where they bring some interns into the building. Other than, so the GT block, that course was developed in coordination with Georgia Tech, but then beyond that, nothing specific.
I'm going to draw your attention and apologize again, maybe another logistics question. I had previously asked Mr. Bryant if his clients were given copies of all of the exhibits in advance, but he failed to answer that question. So I don't know for the
Objection, Your
exhibits
Honor. I'm
that have.
not sure what's happening here.
I'm going to give Ms. Waldman the benefit of the doubt that her point was a logistics one, which is
It is a logistics question.
have your witnesses or her witnesses do they have access to the documents, the exhibits that y'all had agreed would be admissible for purposes of her asking questions about them or seeking to discuss them? Mr. Bryan.
They do have access to those documents.
Okay.
Thank you. Yes, Your Honor, I was trying, and it's actually the ones that are not admissible because I was trying to figure out how to authenticate without sharing a screen.
Okay. Mr. Bryan, have you provided, even if you've not agreed to the admission of the documents, do your clients have access to the documents that Ms. Waldman had referenced other than the ones that were agreed or stipulated for admission?
Yeah, also just for maybe this might help from administrative purposes. I mean, I don't mind if she wants to pull it up and have them look at it on a shared screen. I don't have an issue with that, and if she wants to try to authenticate it that way. But otherwise, can I go ahead and call my client real quick and see if he has access to those in front of him on his computer?
And I don't mind sharing it on a screen. It's just that that's publishing before I've entered it into evidence. And
yeah, and if there was a jury, there'd be a much bigger concern about that issue. But since there's not, I'm perfectly capable, if I say it's not admissible, of forgetting that it exists. So, Ms. Waldman, why don't we start with finding out, asking the witness if he has that document available, and if he doesn't and you need to show it to him, then I think that's probably going to be the best way to do it.
Understood. Thanks, Your Honor. I forgot that was an outstanding logistical question. Mr. Kenter, do you have a copy of what has been marked for identification purposes as Petitioner's Exhibit O?
I received somebody. Yes, I do.
Can you identify? Do you recognize that document?
I haven't opened it yet. Just making sure I'm okay to open it on another screen.
Yes, please.
Okay.
Thank you for asking, Mr. Kent. That's fine with me.
This is our course catalog. I believe.
You believe, or?
Oh, yes, it is our course catalog.
Okay, and when you say our course catalog, you mean Innovation Academy course catalog?
Yes.
Is it a true and accurate copy of the catalog that is published and provided by Innovation Academy?
Yes.
Your Honor, at this time, I would ask to move into evidence Petitioner's Exhibit O.
Mr. Bryan?
One housekeeping issue, Your Honor. I mean, obviously we have objected to the subpoenas. That objection was overruled, or we filed a motion to quash, and that was denied. So I would like to preserve my objection to the extent that any evidence that's coming in is coming in through witnesses who have no legal duty to be here. I just want to preserve that objection. My question is, can we agree that I preserve all of those objections for any evidence that's sought to be introduced through through parties who have objected their subpoenas, or do you want me to object? Or do you feel the need for me to object every time one of these pieces of evidence is offered.
I feel like we have perfected the issue that the respondents object to the manner in which the subpoenas were served on Mr. Kent, Mr. Maloof, and Dr. Looney, and that the court has overruled the objection, at least as to Maloof and Kent for today. And to the extent that the evidence that's coming in is coming in through those witnesses, I think you've established that you have a sort of standing objection to that issue. What I was more interested in is if you had any further objection to the admissibility based on the foundation that's been laid, other than your objection that Mr. Kent shouldn't be here authenticating these documents at all.
No, I do not have an objection beyond the one that I just mentioned.
Okay. Exhibit O is admitted. Understanding that Mr. Bryan, as I mentioned a moment ago, the school board will have a standing objection regarding the authentication and foundational matters related to these exhibits being laid by witnesses that they object to. Go ahead, Ms. Waldman.
Thank you, Your Honor. Mr. Kent, the course catalog makes reference to Innovation Academy implementing design thinking into its curriculum. Can you describe what design thinking is?
Yeah, so design thinking is a it's a working theory for problem solving. So it really serves as a mechanism for our students to try to tackle complex problems, to break them down into small parts and to work through solving those using an iterative cycle in their classes.
And why does Innovation Academy emphasize design thinking?
I could talk about that for a while. It is a the idea that our students need to be solving real world problems, and this but they don't have the skills for that. So giving them a mechanism in which to solve those problems is valuable for us. The design thinking process is very human centered. So the idea of bringing in the humanities and working with people to solve problems for people is important, and in a school that is developed around the STEM fields, to make sure that there's a humanistic aspect to their learning.
And when you joined this school in year 0 as its curriculum person, was this one of your value addeds?
Yes, it was something that I felt very strongly about. The school board was already working towards that, but it was something I thought was valuable.
Thank you, Mr. Kent. I'm going to draw your attention to Petitioner's Exhibit M, which has been marked as Petitioner's Exhibit M for identification purposes. Can you pull that document up?
Got it up.
Do you recognize that document?
I do.
And what is that document?
This is our school profile that we provide to universities and to the community to describe our curriculum.
And is Petitioner's Exhibit M a true and accurate copy of Innovation Academy school profile?
It is. I will say that it changes very often, so I don't know if a new one has been published. As of now, we change it when we get more information, so I'm not 100% sure if it is. Well, this is a 20. Yes, this is accurate.
I'll rephrase my question. Is that a true and accurate copy of the school profile from the 2024 to 2025 school year?
Yes, it is.
I move to enter into evidence a copy of Petitioner's Exhibit M.
Mr. Bryan?
Same objection, otherwise no.
Okay, Exhibit M is admitted. Go ahead, Ms. Waldman.
What are some of the highlights on this school profile?
I mean, all of it. We're very proud of the programming that we have. Our students perform very well academically. It is, I think, the unique programming is the Flex Friday, as we spoke about. Those are all good qualities of the school.
Okay, and the profile highlights that your students win many impressive accolades. can you speak to some of the awards that students at Innovation Academy tend to receive or have received?
Object on
not-
relevance, Your Honor, but
I'm gonna let her go a little bit, but again, we might get to a point where, as much as I'm sure Mr. Kent could talk about how wonderful his school is all the time, that we're going far afield of what we need to know for purposes of today. But for now, your objection's overruled. Go ahead, Ms. Waldman.
This was actually my last question on that topic.
Could you repeat the
briefly-
question? Sorry.
Briefly, some of the accolades that students at Innovation Academy receive.
Our students typically tend to perform very well on standardized tests, although that's not, the thing that we prioritize. They do exceptionally well in, performances, from our CTSOs, which are career tech student organizations. And then, do really, really well, in other activities, clubs and all kinds of great things.
Thanks. I'm gonna turn to student SC. When I say SC, you know who we're talking about. Is that correct?
Yes.
You're familiar with SC as a student?
I am. I don't know SC well, but I do know SC. Yes.
Okay. And you're familiar with her because she attended Innovation Academy for a year and a half. Is that correct?
Yes.
While SC hold on 1 second, because those are in events. Do you have any recollection of the type of student SC was while she was a student at Innovation Academy?
Not the specifics. I know generally that she was a high performing student.
Yeah. And had she participated in the GT program?
The GT block course, yes.
The GT. And in the spring of 2024, sorry, I had to do math. SC was removed from Innovation Academy. Is that correct?
Correct.
And is the only reason she was removed from Innovation Academy the result of the disciplinary hearing that happened in February of 2024?
objection, Your Honor.
What's the basis of your objection? Relevance or the
Personal
earlier
knowledge.
conversation? I'm sorry, Mr. Bryan.
Oh, foundation, personal knowledge.
Okay. Well, if he knows, he can answer. Go ahead.
To my knowledge, that is the only reason.
Mr. Kent, can you pull up petitioner, what's been marked as petitioner's exhibit N for identification purposes?
Did you say N?
N as in Nancy.
Yes, I have it up.
Do you recognize this document?
Yes, I do.
And what is this document?
This is the magnet program requirements for Innovation Academy.
Is this a true and accurate copy of those magnet requirements?
It is. I don't know if it's the proper time to say, but we have not reworked this. I believe this was presented at the beginning of the school year, and policies have changed. So we're in the middle of reworking this. But yes, it is what was sent to the community.
Is this a true and accurate copy of the document that SC would have received at the time she enrolled at Innovation Academy?
I don't know if it would be the correct one when SC enrolled, because there had been changes to that in between. But it was this would have been at the beginning of last year, and I'm sorry, I would need to go through it more carefully to make sure that all of the elements are accurate for the time she enrolled.
Do you know what has changed in the last year?
The attendance policy, the academic requirements, the elements of the technology compliance, and the discipline requirements.
Okay, so those 4 items that you identified, those were implemented for the start of the 24-25 school year.
Correct.
Those requirements were not actually in effect in the 23-24 school year while SC was a student.
Not in some of the specifics. And again, I would have to go back and compare those two, and I just have not done that.
Let me go back to foundation. Is because I'd like to ask a few more questions about it. Is petitioner's exhibit N a true and correct copy of the magnet requirements in effect at the start of the 2024-25 school year?
Yes.
I'd like to tender that document into evidence at this time.
Mr. Bryan?
Your Honor, do you mind if I just ask a quick voir dire question
Sure.
about foundation? Mr. Kent, I'm going to direct your attention to page 3 of the exhibit that you're looking at. Specifically where it says enrollment. Do you see that?
Yes.
Okay, can you read, I guess it's 2 sentences there under the heading enrollment?
Yes, based on the course of study, it is essential that students remain enrolled in FCSIA. Students with a break of enrollment for any reason will not be eligible for return.
Now, is it your understanding that this particular part of this policy was in effect prior to the 2024-2025 school year?
Yes.
Was that policy in effect starting with the 2024-2025 policy?
I'm sorry, ask that again.
I'm sorry. Is that policy listed under enrollment? Was that in effect as of August 1st, 2024?
So yes, the students were not, yes, it was.
Okay. Okay, no further questions, Your Honor.
Thank you, Mr. Bryan.
Mhm.
Ms. Waldman?
I'm sorry, is exhibit N entered into evidence?
Mr. Bryan?
No new objections.
Okay, then exhibit N is admitted.
Let's focus on that enrollment question that Mr. Bryan just asked you. That did not exist at the time SC was a student at Innovation Academy. Is that correct?
So my hesitation on this is we have always communicated with parents and community members. They were not allowed to unenroll and re-enroll haphazardly. The language was cleaned up around that after I came on as the principal. So I hesitate to say that it was that it was this exact language that we used at the time, but we always communicated with families that they were not allowed to unenroll and re-enroll.
Mr. Kent, sorry to interrupt, for my benefit, would it be fair to say that you believe that this enrollment provision was an operating policy, but perhaps not written down before this version of the 24-25 policy?
Yes, that's correct.
Okay, thank you. Go ahead, Ms. Waldman.
The magnet requirements, they also reference a code of conduct. Is that right?
Yes.
And that's the Fulton County School District Code of Conduct?
Yes.
I'd like to draw your attention to what's been marked as Petitioner's Exhibit B for identification purposes. Do you recognize?
B as in boy?
B as in boy.
Yes, this is the student code of conduct.
And just to clarify, this is the student code of conduct that was in effect in 2023, 2024. Is that correct?
Yes, 2023, 2024 school year. Yes,
And that was the year during which SC was suspended. Is that correct?
that's correct.
I would, and is this a true and correct copy of the code of conduct at that time?
Yes.
I'd like to move to introduce Exhibit B into evidence.
Mr. Bryan,
Same objection, but nothing new.
understood. Subject to that objection, Exhibit B is admitted.
At Innovation Academy, what are the potential consequences of not adhering to the magnet requirements contained in Exhibit N?
I'm sorry, can you ask that question again?
What are the potential consequences to a student who fails to adhere to the magnet requirements contained in Exhibit N?
A student could be removed from Innovation Academy or a broad scope of we have progressive discipline in Fulton County, so it could be a broad scope from a detention to expulsion, just depending on the level of the infraction.
That answer might be with respect to the code of conduct. Was that with respect to the code of conduct or the magnet requirements?
I think I'm not understanding your question.
If a student fails to adhere to the magnet requirements, leaving aside the code of conduct, the magnet requirements, the extra things that are required of Innovation Academy, what are the potential consequences?
They could be put on probation or removed from the program.
Okay. And then let's go to the code of conduct. If a student fails to adhere to the code of conduct, what are the potential consequences?
During the 23-24 school year?
Correct.
So a student could be, anything from detention to expulsion.
Outside of the magnet requirements or the code of conduct, in your experience as principal, can existing students otherwise be suspended, expelled, or banned from attending Innovation Academy for another reason?
Again, I'm sorry. Can you ask that one more time?
Sure. Outside of failing to adhere to either the magnet requirements or the code of conduct, in your experience as principal of Innovation Academy, can students otherwise be removed from the school by the school itself, not by their parents?
I don't know. So they're like attendance zone issues. If a student is living outside the district, there are some administrative issues that would come into play, but not general.
Okay. Outside of attendance issues, can you think of any other reasons why a student can be removed from the school?
No.
Turn your attention to the admission criteria for Innovation Academy. You have identified that students need to apply. What does that application process look like?
So the students will apply about December, January. The date is shifted a little bit. December, January, their eighth grade year for attendance the following year. So if a student applies, they are complete the application. They are entered into the lottery. If we go over our seat allotments, and they go into a lottery for attendance. So there's no academic requirement or anything.
Why do you have an application process?
That's been a purview of the district to have the application, so that we know that I think it's a pretty simple logistic need of knowing who is interested in attending.
Okay, and what are the components of the application?
Residency, where they live, what school they currently attend, We have them do an essay. The essay is non-evaluative. It's just to make sure that the students are engaged in the process and to learn a little bit about them. And that's really it.
Did SC apply to
Yes.
Innovation Academy?
Mhm.
And was she accepted?
Yes.
For the 25-26 school year, the school year that has not yet happened, when was the application window?
For this coming school year,
Correct.
the application was December 15th to January 15th.
And when were students notified of if they were accepted?
In I don't know the exact date, but late January or early February.
And applying doesn't bind a student to come to Innovation Academy. Is that right?
Correct. Yes.
So is there a rolling admissions that happens?
Yes, we'll send out our initial acceptances, and then we'll take students off the wait list as the students who initially accept reject or decline their seat.
Okay, and drawing your attention specifically to the reapplication of student SC. I'm going to draw your attention to what's been entered into evidence as Exhibit C.
Okay.
As of August 2nd, 2024, you're aware that SC was intending to return to Innovation Academy?
Yes.
And that's when she initially submitted a reapplication?
I believe so. I would be fuzzy on the dates, but I believe that's correct.
And that's the date. That's, well, I'll let the document speak for itself. And at that time, she was denied admission due to the ongoing litigation. Is that correct?
Objection
Honestly,
to personal knowledge.
Hang on one second. Ms. Waldman,
I
I
why
mean,
don't you rephrase your question?
Yeah, Mr. Kent, were you involved in making any decisions with respect to Mr. Kent, with respect to SC's reapplication process?
Was I involved in the? I received several emails, but I was not the one making those decisions.
You were copied on those emails?
Yes, I was copying them. Yes.
I'll move on. I'm going to draw your attention again to petitioner's exhibit D as in dog, which has been entered into evidence already. And this is SC's second reapplication to Innovation Academy. Is that correct?
What do you mean second?
She reapplied in August. And then she reapplied again in December, correct?
So I remember the communications about seeking re-enrollment, but I don't remember the timing of the applications.
That's fine. I will move on. Were you involved in the determination of what happened to SC's reapplication?
No.
Do you normally, leaving aside reapplications, do you have a role in the application process of incoming students?
Overseeing it, yes.
Okay. Did SC's application that was submitted in the chain that is petitioner's exhibit C go through the normal process?
You mean the normal, like what the typical timeline? It did not.
Okay. What about the typical review process?
No, because we only let students in their freshman year, this was, an unusual circumstance, a one of a kind.
Okay. Have there been circumstances like this outside of SC?
Like this, no.
And so what did you do when you received SC's application process?
I communicated with the district to seek guidance.
Objection, Your Honor, real quick, can we just be clear on exactly, we know that there's been several applications here. Can we just be clear in the questions of being clear exactly which application and which application process she's talking about here? Because we've got the initial one for school, the one in the summer, the one in the winter, and I would just request some clarity in that question so the witness understands what we're talking about here.
Fair enough. Ms.
I
Waldman?
believe I identified the application submitted in petitioner's exhibit C in December of 2024.
I did not see an application in there.
This is the email to Dr. Scott.
Does it include? It is the application referred to in that email exchange. I apologize we don't have the full application because it's an online portal. So I'll rephrase. The application to Innovation Academy for the 25-26 school year, which is what she was provided with, that was submitted in December of 2024. What happened to that application?
I believe that was in it. So I was communicating with the parent and had referenced this to the district because it was outside of the application window. So which is the winner of the student's 8th grade year. This was referred to the district. I referred it to the district.
Okay, so you did not act upon it. You sent it to the district.
Correct.
I don't have any further questions.
Okay. Mr. Bryan, questions for this witness?
Yes, I do have a few questions here. Okay, so Mr. Kemp, we've talked about your role in the admissions process, and it sounded like your role in the admissions process is making initial determinations of incoming freshmen.
Correct.
You do not make decisions related to change of school assignment decisions for someone that wants to transfer to Innovation Academy.
Yeah, I do not.
Got it. Who does?
That the district office would do that, the change of school assignment committee.
The change of school assignment committee.
Mm-hmm.
Got it. Are you on the change of school assignment committee?
I am not.
Okay, got it. Let's back up to we've heard you've fielded some questions about various applications. Obviously there was SC's initial application, for admittance as a freshman.
Yes.
And then there was another application in the summer of 2024.
Correct.
All right. When did when did you first receive communication about either an application or a request for re-enrollment for SC into Innovation Academy?
I believe it was in July, July of 2024.
July of 2024 was when they asked for, Mr. Shonda asked for readmission for SC into Innovation Academy.
Correct.
And do you remember why they submitted that application in July of 2024? What event preceded that?
I believe it was one of the appeals. I'm not 100%, but I believe it was the State Board of Education's appeal.
Got it. Okay. All right. Let's go back to talking about the student assignment committee and who makes the decisions for for someone that is re-entering Innovation Academy. But before we do that, I want to pull up Exhibit N again, which has been admitted as petitioners Exhibit N. That would be the Innovation Academy Magnet Program requirements.
Yes.
And can you please scroll down to page 3?
Mm-hmm.
I'm going to go ahead and focus again on that enrollment issue there. As you had previously read, this says students with a break of enrollment for any reason will not be eligible for return.
Correct.
And as far as you know, that has been the policy of Innovation Academy since its inception, although you testified that perhaps it may have been worded different in the past, but you've always communicated that to the parents.
Yes.
Got it. Is there any reason to believe that this was not communicated to Mr. Shonda or student SC?
We worked very hard to make sure that everyone knew that, just because of the continuity of the program that we have.
Got it. And why is it important let's talk about sort of the thinking behind this policy to begin with. Why would it be a problem for a student with a break of enrollment to return to Innovation Academy?
So we have worked really hard to build this curriculum. The work started in what I refer to as year 0, and the intent is we are asking students to be highly focused in these career pathways and to be able to solve problems in those areas. And so the progression of courses is intentionally built for a student to come in their 9th grade year and maintain that development as they go through. So when they step outside of that, there's a lot of things that they miss over time. I mentioned the project week that we have where all of our students come together to try to solve one collective problem. That doesn't just inform that 1 week of activity. It actually informs the curriculum for many of the classes throughout the year. So not having that information is a really difficult thing for our students and for our teachers, to have to try to manage some students who have that information, some students who don't. Like the research class, our junior year, we intentionally have our courses set up from the GT block where they're introduced to those concepts to the sophomore year where they are working on, this year we call it Pinnacle Prep, where students are taking advantage of our connections with the business community to develop those problems that they want to try to solve that they then take on their junior year. So there's a lot of continuity of programming that doesn't always happen at other schools. We're lucky that we have the ability to do that. Other schools have to, anticipate enrollment at any point. And so that is a distinctiveness to our program that can cause hardships for both the students and for the teachers if they're not careful about how we enroll students.
So in general, would you say that it could be in the best interests of students not to re-enroll at Innovation Academy after an extended break in enrollment?
Yes, I think that's a fair statement.
Okay. All right. I would like to direct your attention now to what has already been admitted as Defense Exhibit A. I'm not sure if you have this. Do you have this one in front of you? If not, Your Honor, do you mind if I share my screen here because it's already been admitted as evidence?
That's fine with me. Ms. Walden, any objection?
No objection.
Go ahead, Mr. Bryan.
Thank you, Your Honor. Do you see a document on your screen that's marked Defense Exhibit A?
I do.
Okay, all right. And I'm gonna this document is a district policy. The title is Change of School Assignment Effective 8/1/2024. Am I accurately reading what you're seeing in the at the top of this document?
Yes,
Okay. And what is your understanding of are you familiar with this policy?
generally, yes.
Do you have any? Well, I'm gonna scroll down to the very bottom here, where it says subsection 11, schools without attendance boundaries. Do you see that?
I do.
Okay, so Innovation Academy is a school without an attendance boundary.
Correct.
All right, and can you read subsection A for me?
I'm gonna get a little closer, but I can.
I can try to increase the
Thank you very much.
zoom in a little bit here. Well, I might have zoomed in a little too much. Can you
Okay,
see
that's
that?
fine. I can make it work.
All right.
Subsection A.
Yeah, subsection A.
These schools will manage the school's applications, lotteries, and wait lists with the support of the superintendent or designee.
Okay, so subsection A talks about the schools without attendance boundaries, like IA says these schools will manage the school's applications. What does that mean to you?
So we set those policies. We set the questions that we are going to ask on the application, and then what the structure of the wait list looks like, how many students we need to take to get to our capacity, and how we run the lottery, inform parents and all of the logistics around that.
Got it. And when you say capacity, what do you mean by that?
So we have a target capacity that we work towards, which is 1,500, and we accept students to make sure that we are hitting that capacity based on the students that we have in the upper classes, and then there's an attrition rate that we have. So we plan for that to make sure that we're hitting that number.
Okay, and where does that 1,500 number come from?
I don't know. So even before year zero, I was on the development team for the building to actually design the building, and that number was shared with us back then with the architects. So I'm not exactly sure where it's derived from. I know it has building capacity, classroom sizes, population, and all of those things. But that's been our target number from the beginning.
Okay. Oh, I'm sorry. And you said you were on some sort of committee at the very beginning before Innovation Academy even got started?
Yes, that's how I found out about it. It was back in 2017 when I was still teaching at Centennial. There was a committee that worked to sort of think through the building design and the curriculum at a very high level, and I sat on that committee.
Okay, and so 1,500 was the number from the very beginning.
Correct.
And you worked with the architects and designers specifically to design the building for a maximum occupancy of 1,500 students.
Yes.
Okay. All right.
To the characterization of it being a maximum occupancy.
I'm sorry, Your Honor, I didn't say maximum occupancy. I said maximum capacity.
Okay, well, I'm going to go with her objection was that your question was argumentative, and we'll just leave it at that and move forward. Go ahead.
I'm sorry. Was the objection sustained?
No.
Okay, got it. All right. Thank you, Your Honor. Now, let's go ahead and look down to subsection 11B. Can you read that for me?
Students with a break of enrollment for any reason must reapply for admission. These applications will be reviewed by the school assignment committee.
Well, I find this interesting. This is a board policy, right?
Yes.
Okay, and it seems to conflict with a policy that we were just looking at a minute ago. Can you pull
our-
up, can you pull up Exhibit N?
Yes, the enrollment policy.
Because that said, and you testified and you read, and it's in evidence, the students with a break of enrollment for any reason will not be eligible for return. But then the board policy says that they can apply for readmission to the student assignment committee, through the student assignment committee. And we'll get into what exactly the criteria that the student assignment committee gets to in a little bit, to the extent that you know. But do you see any inconsistency between this enrollment policy and the district policy?
Objection calls for a legal conclusion, I think.
I can see the two policies, and to the extent that Mr. Kent, I'm sorry, is it Mr. Scott or Mr. Kent? It's Mr. Kent.
It's Mr. Kent. Don't worry. Everybody does that.
Okay.
Okay. Even my own students.
Right. To the extent that Mr. Kent has an understanding, I agree that it could call for a legal conclusion, but Mr. Kent is not a lawyer. And to the extent that Mr. Kent has an opinion, then I will let him opine. Go ahead, Mr. Bryan.
Do you see any conflict, Mr. Kent, between the enrollment policy in Exhibit N and the board policy that in Exhibit A?
Yes.
Okay, let's explore that a little bit. So, to your knowledge, when did the board policy in Defense Exhibit A go into effect?
I don't remember the exact date, but it was I believe early this school year. So in probably August of 2024.
Let's just say hypothetically it was August 1 of 2020. Okay. And this policy in N, the enrollment policy in Exhibit N, if it's in conflict with when you have a policy of your own school that's in conflict with a policy of a board policy, or it's in conflict with something that the board has done, which one do you follow at that point?
Oh, the board policy.
Okay, got it. And let's talk about so if the board policy went into effect on August 1st, 2024, are you planning to change your enrollment policy for FCS Innovation Academy to reflect that?
Yes, we are.
Have you done it already, or is this still what's on paper now?
This is still what's on paper, but we are pushing out a communications shortly to our to the students for next year, at all grade levels to clarify that change.
Got it. Okay. Stop sharing. Let's go up to I'm going to scroll up to general guidelines here. And this is section 1C. Can you read section 1C for me?
Schools must have available permanent learning space and staffing capacity to be considered for a change of school assignment request.
And can you read subsection 1D?
Schools will be considered to have space based on having enrollment of 95% or below their stated capacity over a 3-year projection.
Okay, and remind us again, what is Innovation Academy's stated capacity?
1,500 students.
And so what would 95% of 1,500 be? I'm sorry to put you on the spot here.
Why would you make somebody do math like that?
Right, in front of everyone. I think it's 14, it should 1425, I think, is right thereabouts. God, my math teachers are gonna hate me for this.
Got it. Well, either way, it's somewhere in that range. How many students were enrolled at Innovation Academy in January 2025?
I believe it was 1501 at the beginning of January.
Got it. And is 1501 more than the capacity of 1,500?
It is.
All right. And is it more than the capacity of 95%?
Yes, definitely.
Okay. I'm gonna stop sharing this screen here. And I'm going to bring up another policy or another exhibit here that I believe we have stipulated to. I'm sorry, there's a lot of exhibits here. I'm going through this list. I am looking for the okay. I am looking at Exhibit G. Now, do you have that? Can you pull that up and bring that in front of you?
Yes.
And do you can see the title of this? Can you read the title of this document?
Enrollment denial letter from the Office of Student Assignment.
And if you scroll to the second page, there is a letter there. Do you see that?
Yes.
And it's a letter to well, to SC. Obviously, a lot of this is redacted, but you can see the initials SC up at the top there, right?
Yes.
Okay. And this is a denial letter of SC's application for to the school assignment committee. Is that right?
That's correct.
All right. It says there that student enrollment at FCS Innovation Academy is at maximum capacity for the 2024-2025 school year. Am I reading that accurately?
Yes.
Objection to this witness testifying. I believe on direct, he testified that he was not the one who made that decision.
I'm going to sustain that objection, Mr. Bryan. You can move on.
Okay. Mr. Kent, you're not on the student assignment committee.
I am not.
Okay. You didn't make a decision here, did you?
I did not.
Let's talk about the extent of your involvement to whatever it is in this whole process. Did you attend a meeting of the student assignment committee?
I did.
And what was the purpose of that meeting?
Dr. Crumbly, my zone superintendent, my immediate supervisor, was slated to attend that meeting, but had a conflict. And so asked me to stand in case there were any questions from the committee about our school and or enrollment.
And specifically in relationship to SC's application.
Correct.
Okay. And did anyone ask you, or did you offer anything to the student assignment committee during this during this meeting?
Hang on, forgive me for interrupting, Mr. Bryan. Just to your earlier objection about being specific about which application we're discussing.
Yes.
Obviously, we're not talking about the original one where she was accepted. We're talking about, are we talking about the August or the January one?
That is a fair point, Your Honor. When the meeting that you attended for the student assignment committee, was that in relationship to which application was that in relationship to? The one over the summer or the one over the winter?
I believe it was specifically for the request submitted to the school change of assignment committee. Not an application that went through the school from Innovation Academy, but went to the change of school assignment committee.
Got it. All right. So this was the we'll just call it the winter application.
Yes.
Got it. Okay. So you attended a meeting of the student assignment committee related to the winter application for submitted to the student assignment committee for re-enrollment at Innovation Academy.
Yes, I did.
All right. And were you asked any questions by the student assignment committee?
Yes.
And what was the question?
About the building capacity.
Question, hearsay.
I'm sorry, could you repeat the question, Mr. Bryan?
Did you offer any information or opinions to the student assignment committee?
Yes.
I'm gonna overrule the objection. Go ahead, Mr.
That
Bryan.
was a different question. I think he withdrew the first one.
Okay,
Yes.
fair enough. Go ahead, Mr. Bryan.
Did you offer any information to the student assignment committee in relationship to SC's winter application?
Yes.
And what was that?
The capacity of the building, what our enrollment was,
Got it. And what did you tell them your enrollment was?
1501.
And, or I'm sorry, what did you tell them your capacity was?
1500.
And what did you tell them that the current enrollment was?
1501.
Got it. Okay. Let's take a step back and talk about, I know that you testified earlier that you have this, that you do have a lot of involvement in the initial application process for freshmen.
Correct.
And your goal is to get to 1500.
Correct.
Right. And why is it important that Innovation Academy stick to the 1500 number?
There's a lot of reasons why it's important. We build our staffing on those numbers, the learning spaces that we have. We have a lot of unique, learning spaces, from engineering labs to IT labs, equipment that's specific to the programming. And we build our budget around that, our staff allocations around those numbers. So there's a lot of reasons with the class sizes that we have, what the expected capacity we have in those different spaces is are all important considerations for that.
In fact, you testified earlier that the school was specifically designed to handle 1500 students.
Correct.
Got it. From the very beginning. Now, what are some of the problems that that would occur if Innovation Academy was forced to take on more students than 1500, if it had to go over capacity?
Which it currently is. Just to make sure I understood Mr. Kent's testimony, it's currently over capacity by one student, correct?
Well, I'm sorry, Your Honor. I did not ask him what the current capacity is today. I asked him what it was in January when the application was considered.
Okay, well, it was 1501 then. So I just was making sure I understood that testimony. Go ahead, Mr. Kent.
Yes. Okay. So now let's go back, and we all agree that before January of 2025, you were over capacity by, at least at the time, by one.
Correct.
Right now let's go. Let's talk about some of the problems that Innovation Academy might face from having too many students, from being over capacity. Can you explain those for us?
Yes, it's a complicated issue when you're looking at student enrollment, staffing. You've got to make a lot of long-term decisions early in the process, and when you go over those numbers, there can be some significant problems that come along with that. So for scheduling, so if you bring in too many students, then you should have, you have to modify schedules. You have to adjust classes for different students. And one of the biggest issues, and I think why we have the 95% threshold for the district policy, is it's not just a one size fits all. We've got students who are collected in one class, and if I have an extra, if I were to have an extra 30 kids, that would be one extra teacher. But because of that, it would push the class sizes up in all of the subjects. And I can't hire a 0.2 math teacher, 0.2 English teacher, 0.2, on throughout the building. So you have to make decisions about what those sizes are. So then if you're over enrollment, you're stuck in a situation where you've got to make some hard choices and collapse classes at different areas to make sure that you have enough classes to fill those buildings. That's a teacher that did planning over the summer for, or someone that you hired for a particular class that then you have to pull from that so that they can teach another subject where you're over enrollment. It causes supervision problems. And so you've got to hire for those things. You've got to make these adjustments. And, even with the small increase of enrollment, there's significant issues that follow on with that. And the effect isn't just for, one kid at one time where you change a schedule and move it back and forth. It is, if I have to open another section of geometry, then I have to take all of the students from all of their other geometry classes to balance it out. And when you make those moves, you have to change all of their schedules. And this doesn't happen in the first week of school. It happens, whenever it happens, you've got to pull those kids. They've developed relationships. They know the teachers, teacher assignments and teaching style can be different. They could have started on different things. So it's very disruptive to the school community when you make those changes, both to the students and to the teachers, you know, and to the administration. You have to work through all of those schedule changes.
Thank you. No further questions.
Thank you, Mr. Bryan. Ms. Waldman, any redirect?
Yes, thank you.
Oh, actually, before you do that, I actually have a few questions, and I typically will do it at this point so that if I mess up y'all's carefully crafted questioning of the witness, y'all can fix whatever I've messed up. So if I may interrupt, Ms. Waldman, I really just have a few questions, and some of them I admittedly probably should know, but I'm less clear on it. I think the lawyers have a lot of walking around knowledge that I maybe don't have as good a basis in. So I heard you testify earlier that you have been associated with the school essentially since its inception, but you've been the principal since 22. Is that right?
That's correct. Yes.
Okay. What was the first year that Innovations Academy had students in the building?
Um,
The first school year?
so the COVID year was our planning year. So 2021 was the planning year, then 21, 22.
Okay.
The first year.
And so what is that, like 4 school years-ish?
Our first freshmen are graduating this year.
Okay. And we talked a lot about the need for continuity in the program and issues associated with re-enrollment after a break. In your memory, has it ever occurred that a student has had a break in enrollment and then been readmitted for any reason?
Short term. So for like a month or something, if a student was in an inpatient medical facility, you know, then we made accommodations for those students. But I think short periods, maybe I couldn't speak to exactly how long, but definitely less than a year.
Okay. Okay, but it has happened that students who had a break in enrollment were re-enrolled in the program, although your recollection is that it was a short break. Is that right? Or relative to this one anyway?
Yes, and I will also say that was when we were under enrollment also.
Okay. And then there was some discussion about the board policy. I think it's Defendant's Exhibit A that was adopted in August of 24, and it looks like it was revised, reviewed, whatever action the board might have taken again in December of 24. Do you know why? I mean, if you don't know, that's fine, but do you know why that change was made to change what appears to be a magnet requirement that a student is not eligible to return, and then an adoption by the board in their own policies that an enrollment break requires a reapplication?
I should follow those meetings closer than I do. So I don't have really any knowledge on that.
Okay, fair enough, Mr. Kent. And then I think my last question is for the students who, in your experience, where you've had a few students, I don't know exactly, you didn't put a number on it, so I'm not going to, but you've had students who had a break in enrollment. Were they required to reapply, or were they just re-enrolled?
They were just re-enrolled, but I'm trying to think if there are any exceptions to this, because I think they were all, to my knowledge, I think they were all, we knew about the break in enrollment before they left.
Okay, fair enough. And I understand there might be different reasons for those breaks in enrollment than what we have here. I'm just trying to get a feel for the handling of those issues when they occurred. Thank you, Mr. Kent. Those are all the questions that I had. Ms. Waldman, did you want to redirect the witness?
Yes, please. Let's start with the capacity issue, Mr. Kent. I'm going to draw your attention to Exhibit M, and if I may share, Your Honor.
Yes.
Exhibit M is Innovation Academy's student school profile for 24-25. Is that correct?
Yes.
And on page 3, there are demographics with respect to the student body as of the fall of 2024. Is that correct?
Yes.
And the enrollment in the fall of 2024 was 1521. Is that right?
Yes.
So between the fall and we'll call it the winter meeting at the student assignment committee, there was attrition.
Yes.
So you lost 20 students.
Yes, and I think most of those happened like the first week or two when they went, but students leave throughout the year.
Okay, and students from across all grades leave throughout the year?
Yeah, it varies by grade, but yes.
Okay, so I have no further questions about that document. I'm going to stop sharing.
Ms. Waldman, what exhibit was that?
That was Exhibit M, as
Thank
in
you.
Mary.
Thank you. Go ahead.
The 1,500 target that you identify, that's really a target for your own planning purposes, correct?
Objection, Your Honor.
Overruled.
How do you, can you ask the question again?
It's not a hard and fast rule.
Objection, Your Honor. That is argumentative and calls for a conclusion. Hard and fast rule. I mean, we have a board policy on this, so I object.
You can rephrase if you want, but the substance of what Ms. Waldman's trying to get to, I'm okay with. Perhaps she could phrase it differently. Go ahead.
Mr. Kent, you have accepted more than 1,500 students into your student body.
Accidentally.
But it has happened.
It has.
And SC's application that she submitted in the December 2024 time period called application for 25-26, as well as her application for the student assignment application. Those all happened before you accepted your incoming 9th graders for 25-26, correct?
Yes.
So in terms of capacity, if she were intending to apply for 25-26, you could have addressed that issue through incoming acceptances, correct?
Objection, Your Honor. Maybe this is in the record. Maybe I just missed something here, but we have so far my understanding, to keep the application straight, we have a summer application, we have a winter application. Well, which one are we talking? We have the application in July of 2024 for readmission to Innovation Academy. Then we have another application in.
Mr. Bryan, sorry to interrupt, but
Yeah.
I understood Ms. Waldman's question. If the witness did or didn't, he can ask for clarification. But I understood her question to be that both of the applications were submitted prior to Innovations making its decisions in January 2025 about the admission of the 25 class. That's what I understood the question to be. That may be right or wrong, but that's what I understood it to be.
And just to be clear, it's the application to the student assignment committee. I thought I heard, and maybe I just misheard this. Maybe I'm off here. I thought I heard she say that she submitted a third application for admission for 2025-2026. If I misheard that, I apologize.
I'll break my questions up because that's proper form. The application that SC submitted to Innovation Academy was titled Application for 25-26 School Year, correct?
I might need to see I'm not sure which one, and I'm not trying to be difficult. I don't know which one we're referring to. I will pull up an exhibit in a minute. It should be at the bottom of Exhibit D. Okay, yes, this is right. The winner. Okay, yes. And so that application was titled for 25-26 school year, correct? Correct.
And that was the application that SU was instructed to fill out initially when she asked to return to the school, correct?
I believe so, yes.
And so that application came before any decisions were made with respect to the incoming 25-26 school year, correct?
Just checking the dates. Yes.
I'll refrain for Mr. Malou for the next set of questions. Anything else? Sorry, if I can have 30 seconds just to make sure I'm not missing something in my notes here. That can be. I have no other questions.
Thank you. Mr. Bryan?
Yeah, I just want to go ahead and clear up a couple things here, make sure that I understand Mr. Kent's testimony. Okay, so you testified in response to your honor's questions that some number of students had been disenrolled and then re-enrolled without having to apply to the student assignment committee.
Correct.
And you said, can you again describe sort of the circumstances surrounding that to your best of your memory?
Yeah, I mean, I'm worried I'm going to miss something, but the vast majority are either, a parental dispute where they changed where they lived with the guardians, or medical issues where a student was in an inpatient treatment facility where they have their own, educational institution, those kinds of things.
Okay, so in any of those situations, were those students sort of formally issued a letter saying you are disenrolled from Innovation Academy?
No.
They just stopped attending because they had, a medical reason, for example.
Correct.
Right, but there was no formal disenrollment process.
They are removed from our system, but no, nothing beyond that.
Got it. And then as soon as their medical issue was over, they just popped back right into class.
Correct.
Got it. Okay. All right. Let's talk a bit about the we saw an exhibit a minute ago that said that you had 1,521 students at the beginning of the 2024-2025 school year.
Yes.
Can you explain why you had that many students?
Yes. We missed our target. That we and all of the issues I mentioned earlier were real ones that we had at this time period. So in order to be good neighbors to our school, we try to project what our enrollment is going to be at the end of May, so that other teachers or other schools aren't losing teachers, or positions where they would have to remove a teacher from a building because their enrollment is lower. So we try to set that at the end of May, and we use the attrition numbers that we have had, the percentage of students that we have lost in the previous years. And I will say it's a testament to the school that attrition rate over time has dropped. So when we enrolled those students, we had assumed that the attrition would be higher, but it wasn't. We went over the maximum enrollment.
And so you went over maximum enrollment.
Yes.
Got it. Okay. And what problems did that create?
A lot. It was, from geometry classes. So geometry is a class a lot of our students come in and take as freshmen. So those classes were all freshman classes were over our what we would like our enrollment to be. So then you have to make a decision, because like I said, you can't hire a 0.2 math teacher, a 0.2 English teacher. So we had to decide where the most problem was, and we brought in a math teacher to manage that. But then we had to readjust all of our other classes. Those math classes were high. Our biology classes were also high, but I couldn't bring somebody in for that because you only have that one position. So we had to collapse an AP environmental class, and then those enrollments go up. We have to, send letters to all of those parents to let them know that their classes are changing. and then all of when you do that, I think it seems like it's you just kind of move kids from here to here, but it's a flow on effect where if you move one schedule or one class in a student schedule, you have to move, all kinds of schedules because you're taking them from other classes, which only are offered in one period or another. And oftentimes there are conflicts where you have, one class that is offered in third period and the only low number of, students in a class is on that third period. So then you have to switch kids from that, one class. It just becomes a domino effect where you make one change and it really impacts the entire operations of the school. Not to mention, supervision of those students, cafeteria capacity and, where we put our students during lunches. And it might not seem like a lot because you're just thinking it's part of one class, but really it's an incredibly problematic situation to be in.
Got it. And do you plan on exceeding that 1,500 again after your experience with that?
Absolutely not.
Got it. Okay. Now let's talk about the applications. I know we're going. There's a lot of confusion about this right here. Okay. Let's say someone is attending another Fulton County high school. All right. A generic one, any attendance zone school, and they want to come to Innovation Academy. Would they submit an application to Innovation Academy?
No.
No. What would they have to do in order to go through the process to be enrolled at Innovation Academy?
The change of school assignment committee.
Okay. And you don't run the change of school assignment committee?
I do not.
You are not a decision maker there?
No.
Can you consider applications for enrollment for a student that is a junior attending another high school at an application to Innovation Academy?
We do not.
Okay. No further questions, Your Honor.
I have one follow-up question. Do you target, so we've talked a lot about enrollment targets and 1,500 capacity, et cetera. Do you have enrollment targets or capacity per grade?
No, we have the 1,500 capacity, and then we use our student numbers for each class that we have, and then we use that to allocate the seats for incoming freshmen.
And am I correct that through forces of attrition that typically the freshman class is going to be your largest class each year, and then the upper classes will be slightly smaller?
Yes, that's
okay.
right.
And am I also correct that if SC, she was unenrolled when she was a sophomore, but but the enrollment she's seeking at this point would likely be for her senior year of high school. Is that correct?
Yes, I believe so.
Which would be the 25-26 school year?
Correct.
Okay, thank you. Anything on those questions, Ms. Waldman?
Those were actually most of my questions. I just have one more question. The rule that Mr. Bryan has asked you about, the Innovation Academy's rule that if you are unenrolled, you can't come back. And you talked about that being something you publicized to parents. What was the purpose of, well, let me rephrase. That rule was to discourage parents from disenrolling their children. Is that right?
Objection, Your Honor.
Yeah, overruled.
No, the reason for that is because we have a program of study that, we've spoken about this, but the issue of moving from one grade to the other, that it needs to be with a program that we put in place, it is detrimental to the student and the school to be pulled out and then come back in. So the idea, it wasn't about, we lose students to our other, high schools all the time. We have incredible high schools around us. So, that's just a known quantity. But if a student unenrolls and then tries to come back, that's problematic for the program that we have in place.
Right, as a matter of student choice to unenroll, correct?
Objection, Your Honor. That's not what the policy says.
Overruled.
Can you ask the question again?
And you're trying to inform parents and students that if they choose to unenroll, they will not be given the opportunity to come back. Is that right?
Yes.
No further questions.
Mr. Bryan?
One last question. The policy says that students disenroll for any reason. Is that right?
Yes.
It doesn't say only for when a student is disenrolled because a parent made a choice. Does it?
Correct.
Okay. No further questions.
Thank you. Okay, Ms. Waldman, are you concluded with your examination of this witness?
I am.
Okay, sir, you are excused. Thank you for your time. I'm sure we're all happy to let you get back to the much more important work of the school. So go ahead, sir.
Thank you. Thank you, ma'am.
Okay, it is 11:30. I don't know who is going to be your next witness, Ms. Waldman.
Mr. Maloof.
Okay. I want to go ahead and get started with that person. I just want to give you all a heads up that probably around 12:15 or so, I'm going to take a break so that I don't starve to death, and so that y'all don't also starve to death. So we'll get what we can get done and then you can expect a brief break, maybe 20-30 minutes tops around 12:15 or so.
I do believe Mr. Maloof will be much shorter, Your Honor.
Okay. Mr. Bryan, do you have Mr. Maloof available?
Ashley, can you chime into that?
Yes, give me a moment, and we'll have him available in probably 90 seconds.
Okay, excellent. Thank you.
Okay, he is, I believe, logging on right now.
Okay. Mr. Maloof, can you unmute your Zoom, please?
Yes, thank you.
Thank you. Mr. Maloof, you've been called as a witness by Ms. Waldman. I'm going to ask you to raise your right hand. Do you swear the testimony you're about to give the court will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, sir. You may lower your hand. Go ahead, Ms. Waldman. You're muted. There you go.
Mr. Maloof, can you please state your name for the record?
Yes, Noel Maloof.
And what is your current occupation?
I'm the Chief Operations Officer for the Fulton County School District.
How long have you been the Chief Operations Officer?
In Fulton County Schools, I've been here 4 years.
And what are your responsibilities as Chief Operations Officer?
I oversee the Transportation Department, the Nutrition Department, Capital Programs and Construction Department, the Maintenance Department, Operational Planning and Student Assignment.
Okay.
And School Nutrition.
You started with nutrition. That's a good one.
Oh, sorry.
I'm gonna focus on your role as overseeing the Student Assignment Committee. What does it mean to oversee the Student Assignment Committee?
Sure. By our policy, I lead the Student Assignment Committee, so it is my job to bring the members together, develop the committee, and make sure that they're meeting on a regular basis and take their recommendations and validate their recommendations on any student assignment that comes to them through application.
What is the Student Assignment Committee?
Certainly. Anytime a student wants to attend a school that is outside of their attendance zone, they make application to the Student Assignment Committee, and that is reviewed by that committee.
Are you familiar with Student SC?
Yes,
And just so that we're all clear, when I say Student SC, you know who I'm referring to.
that is correct.
How are you familiar with her?
Through this case and also through a application that she made through the Student Assignment Committee.
Okay. And do you recall the details of when and how she applied through the Student Assignment Committee?
Sure. She applied in January of this year to go to Innovation Academy. It's outside of their window, so she made application to our committee at that time.
Do you know why she made the application to your committee as opposed to through other means?
Objection, Your Honor. Calls for speculation.
I
Well,
asked
she
if
asked
he
if he
knows.
knew. If he doesn't know, he can say he doesn't know. Mr. Maloof, your objection's overruled, Mr. Bryant. Go ahead, Mr. Maloof.
Thank you. She made application through our committee, I assume, because it is part of our process to go to any school that's outside of your zone school.
Okay. Are you aware that SC had previously attended Innovation Academy?
Yes, I'm aware of that.
Having applied through the Student Assignment Committee, what was the Assignment Committee's decision?
Their decision was to reject her application and recommend that she stay at Alpharetta High School.
Okay. Was it a complete denial, or was she placed on a wait list?
My understanding is that she was placed on a wait list.
Okay. And are you familiar with how many students are on the wait list?
I'm not.
Did you look at the wait list when making, and let me step back. Are you the person with ultimate authority over the decisions of the Student Assignment Committee?
Yes,
So when they make a recommendation, it has to go to you before it's a final recommendation?
that's correct.
Okay. Did you, are you personally familiar with how many students attended Innovation Academy?
Could you rephrase the question? I want to, the reason for that is are you talking about current enrollment?
Enrollment at the time SC applied?
So I don't have the exact number, but I know that they were at their capacity of 1,500 students.
Okay. Are you aware of how many students are currently at Innovation Academy?
I couldn't give you the exact number, but I am aware that they're at their capacity of right around 1,500 students.
Okay. Are you aware of when making a determination about whether student SC was placed on the wait list, was that wait list, did that wait list carry over through to the 25-26 school year?
I am not sure on that. My understanding is that the request for is an immediate placement, and that would make my assumption on this. We did not define it out in the letter that wait list piece was for this year.
Yeah, was she given any information about whether she could resubmit her application for the 2025-26 school year?
No.
Were you under the impression that she only wished to attend if it was for immediate enrollment?
That's our assumption on any applications that come to our committee.
Okay. And have you received personal communication from SC's father, Mr. Chanda?
I don't recall. I don't recall communication coming to me from him.
Are you familiar with the timeline for when students get accepted to Innovation Academy for the upcoming school year?
Yes, those applications. I'm sorry, go ahead.
What is your understanding?
My understanding of the application process for them, and I don't have the exact dates, is that starts in late fall, moves through December, and those decisions are made early January.
And so capacity concerns with respect to Innovation Academy and SC's enrollment could have been alleviated with an admission for the fall 25 school year. Is that correct?
Objection, Your Honor. Argumentative.
Overruled. Go ahead.
The application process for Innovation Academy is for rising freshmen. So I don't know that that application process would be relevant in this situation.
What about an application through the student assignment?
So through the student assignment committee, if you're asking about capacity, the student assignment committee considers capacity above 95% of the enrollment capacity at or above what we would approve for a student. So I'm assuming, and again, this is just an assumption, that the enrollment for next year, they would enroll at capacity and there still would not be room for us to add a student.
Give me 1 second to find an appropriate page on an exhibit. I'm gonna draw your attention to Exhibit D, then I'm gonna share my screen. Can you see Exhibit D?
Yes, I do.
And that appears to be an email to you. Is that correct?
That is correct.
From SC's father, Mr. Chanda.
That's correct.
And in that email and personal plea to you, I'll maybe draw your attention on my screen. It indicates that SC wishes to graduate from Innovation Academy, correct?
Okay.
So they're making a clear, does that to you indicate that they're making a preference to rejoin Innovation Academy? Solely limited to that specific date in time?
Objection, Your Honor. I mean, she's asking the witness to characterize an email here. It speaks for itself.
Tend to agree. I'm going to overrule the objection.
That's
I'm
fine.
sorry, sustained. I apologize. I was sustaining the objection.
I will. I have no further questions.
Thank you, Mr. Bryan. Questions for this witness?
Yes, Your Honor. Thank you. Okay. Mr. Maloof, thank you for being here today. You testified earlier that you are involved in the student assignment committee process.
That's correct.
And in fact, you lead the student assignment committee.
That is correct.
I am going to pull up what's already been admitted as Defense Exhibit A. Your Honor, may I share my screen?
Yes.
Do you see a document in front of you, Mr. Maloof, that says Defense Exhibit A?
Yes, I do.
Are you familiar with this document?
I am.
What is it?
This is policy JBCD, which generally guides our change of school assignment outside of any zone schools.
Got it. Okay. Let's look at subsection 1A. Can you read that for me?
Yes. The Fulton County Board of Education expects all Fulton County students to attend the school serving the geographic area in which the student resides per policy AD school attendance zones.
And can you read subsection B?
Certainly. There may be instances where families or students need
The documents in evidence. I don't believe we need him to read them out loud for us.
I mean, I'm aware of it, Mr. Bryan. I can read it. It's in evidence. I've already heard it from another witness. So if you want to target your questions instead of having him read the same ones, that would be helpful.
Okay. In fairness, Mr. Malou, subsection B says that generally students, are supposed to attend their attendance zones, but subsection B says there may be some situations where we need to send someone to a school outside their zone, right?
That's correct.
Okay. And it says based on the requirements set forth in this policy.
That's correct.
Okay. Subsection C is one of the requirements set forth in this policy, right?
That's correct.
And it says students must have available permanent learning space and staffing capacity to be considered for a change of school assignment request.
That's correct.
And that is related to, that is related to the space of the physical environment and staffing and other issues that schools have to consider when determining whether they have space or not.
Yes, that's correct.
Subsection D says schools will be considered to have space based on having enrollment 95% or below their stated capacity over a 3-year projection.
I'm going to renew my objection to simply restating the policy.
Sustained. I don't know that it changes anything, Mr. Bryan, for you to read it instead of the witness to read it. I mean, the documents and evidence, I see what the policy says. If you want to ask him questions to help me understand how that policy is implemented or how it's, applied, that's fine. But the policy says what the policy says, and we can all agree on that.
Okay, so a school that is at least 95% enrollment is not eligible for a change of student assignment request, right?
That's correct.
Okay, and this is a requirement of the board policy.
That is absolutely correct.
And you are required to follow this policy as part of the student assignment committee.
Yes.
Scrolling down to subsection 11, a student with I don't know how to phrase it any better than what the policy does, but generally a student with a break in enrollment for any reason has to reapply through the student assignment committee, right?
Yes, that's correct.
So because SC had a break in enrollment for over a year, under the policy, she had to apply through the student assignment committee.
Yes, there was no other mechanics for that.
Right. She couldn't just submit an application to Innovation Academy, could she?
No,
No, had to be through the student assignment committee.
that's correct.
Got it. Have you considered any application from the student assignment committee from SC for school year 25-26?
No.
Okay. All right. Now, the student assignment committee, as we mentioned, is required to comply with these provisions in subsection 180, which is capacity. All right. Now, what is your understanding of Innovation Academy's capacity?
So Innovation Academy's capacity is 15 FTE, which is full-time equivalency, which equals students essentially. And that is based on the available space in the building and what we align to with the Georgia Department of Education's requirements.
And how, let's see, give me a broad overview of how how a school district arrives at a number for capacity.
So this is a broad explanation. It is a more complicated formula in the background, but essentially we look at a number of things. So for any kind of specialized school, we would look at what the programmatic capacities make sense to align classrooms to. So essentially what I'm saying is that you start with the instructional program and what alignments you need to make with that. Then we look at what's the most efficient operationally for our student populations. The board ultimately makes a determination. We have a guide called our educational specifications that determines what sizes schools will be built to. And that's not just a square footage size, that's really determined about the number that I talked about earlier, which is the FTE number. So once that's determined, then there are Georgia Department of Education and local requirements on what we would put into that building, meaning number of classrooms, types of classrooms, and sizes of classrooms, along with common spaces, et cetera, that guide how any school is designed and developed and built.
Got it. So it's a pretty complex process.
It is.
Involving a lot of different criteria.
That is correct.
And why is it important to stick to these capacity numbers?
So ultimately, these specifications and capacity numbers really provide optimal both safety and health for the students, as well as the proper instructional environment for the students. You can't build a building without science rooms, and you have to have hallways that are big enough for fire egress, et cetera, et cetera. So we stick to that pretty closely because, again, you don't want to put more students into a building than the building is designed for, both from an operational standpoint and an instructional standpoint.
Got it. And to your knowledge, are there any Fulton County board policies about capacity?
Yes.
Okay, and can you generally describe what those policies are?
Mr. Bryan, before he does, can you take down your screen share so I can see the witness more on my
Oh,
screen?
yeah. Yes,
Sure.
of course.
Thank you.
Okay, I'm sorry. I'll rephrase the question, or I'll restate the question here. Are there any board policies about school capacities?
Yes.
Okay, and generally, what are they?
So we overall, our school capacity policies dictate how we build buildings, what we enroll students to as a overall capacity, and then again how we will assign students to a particular school, and then what to do when you are over capacity, for example, rezoning, things to that effect.
And what goes into coming up with a particular number, a capacity number for a particular school? Are there any, let's see, is there any consideration of, for example, state or local regulations?
Certainly. All of our policies, all of our practices that go into developing a school capacity align with what the Georgia Department of Education minimum requirements are. All of our plans are reviewed by in conjunction with the architects, but also by the Georgia Department of Education before they're even approved. And they all have to be approved by the Georgia DOE. The reason for that is so we provide consistency across the board and meeting those minimum expectations. We also have some local expectations that are outlined in our educational specifications, which is, again, part of that policy question, which is what policies guide our enrollment capacities. We are required by the Board of Education to review every 5 years our educational specifications, which again is that document that and guidance that gives to space and capacity. We have prescribed capacities for different levels of schools. For example, high schools could be 1,500, they could be 1,850, and this is really for our traditional comprehensive high schools. We developed an ed spec for Innovation Academy that was 1,500 students. Again, all of this matches the need for the instructional programs that are going to be there and the need for the number of students that we have there and an overall consistency of how we build the buildings.
Okay, let's take a step back again and talk about SC's application specifically. Student Assignment Committee denied her application.
That's correct.
One of the reasons they cited was because Innovation Academy was over capacity.
That's correct.
Okay, and it's your understanding that the capacity is 1,500, and there were at least 1,500 students at the time of SC's application.
That's correct.
Okay. And also the school policy says that only schools that have enrollment of 95% or below their stated capacity are even eligible for a student for a change of student assignment application in the first place, right?
That's correct.
And so Innovation Academy was both at its maximum capacity and it was well over its 95% capacity as required by the school board policy.
That is correct.
Is that one of the reasons why her application was denied?
Yes.
Okay. The letter also said that it was the Student Assignment Committee's decision that it was in the best interest of SC to remain attending Alpharetta High School.
That's correct.
Okay. Now, can you explain to me why it might be in SC's best interest to remain at Alpharetta High School versus Innovation Academy?
So at a high level, Innovation Academy has a very prescribed curriculum that begins in the 9th grade and continues all the way through the 12th grade. They have a culminating project at the end of the 12th grade year that they work on all through those 4 years to develop the skills and the material and the knowledge to make that happen. A big break in enrollment for that can cause some problems or impossibilities of making up that curriculum. When you look at a school like Alpharetta High School, which has many of the same offerings, many of the same pathways. In fact, they have a full complement of advanced academics there. That school is, as most high schools are, much more capable of addressing breaks in enrollment, getting kids caught up, making sure that they stay on track for graduation. Those mechanics are not as pronounced and really don't exist in the same way at Innovation Academy because it's such a pronounced program all the way through.
Well, let's talk about Alpharetta High School. I mean, how would you describe Alpharetta High School?
I would say it's top tier high school.
Top tier? What do you mean by top tier?
So it has a high graduation rate. I think they're at about 98% graduation rate, which is always a first mark of a top tier school. They have students that go on to advanced academics in post-secondary. They have students that go on into career fields. They have and I keep mentioning the advanced academic program. They have both a full complement of advanced placement courses, as well as a unique program in the International Baccalaureate Diploma program that students can access. They have a full complement of career technical and agricultural education, so CTAE classes, and that's where you find your engineering pathways. That's where you find your logistics pathways, any of those career pathways that focus on STEM education and providing students those other options for education there. In addition to that, they have a full complement of athletics and extracurricular, performing arts, visual arts. So there's really nothing that you can't access or have opportunities to at Alpharetta High School. And that's not to be said for all the schools around this country for sure. So I would consider that one of the top tier schools.
Okay, I am going to share my screen here and show you what's already been admitted as Petitioner's Exhibit M. Do you see a document in front of you, Mr. Maloof?
Yes, I do.
Does it say FCS Innovation Academy High School Profile?
Uh-huh.
All right, I'm going to scroll down to, let's see, average standardized test scores over here. Do you see it? Can you see that? I know it's probably pretty small.
It's small, but I can see it. Yes. There we
All
go.
right.
Thank you.
All right, there's a little Excel mini spreadsheet over here, and it says FCS Innovation Academy, Fulton County Schools generally, Georgia Nation.
Mhm.
Where would Alpharetta High School sort of slot in there?
So I don't have their exact numbers off the top of my head, but I am positive that they would fit, well in between Innovation Academy and Fulton County Schools averages and certainly above Georgia and the nation. I think their scores tend to be on average about 100 points plus better than the Fulton County Schools average.
All right. And so probably closer to Innovation Academy than certainly your average public school in Georgia, and certainly beyond your average school in the nation.
That's correct.
I'm going to stop sharing my screen here. Do you know which school has more AP courses, Alpharetta High School or Innovation Academy?
I'm going to assume that Alpharetta High School does. I think they have more offerings there than at Innovation.
Well, I can't
Forgive me
ask you to
Mr. Bryan, sorry, forgive me for
Yeah.
interrupting, but I live in Fulton County. My kids, I have children who are high school age who attend Atlanta public schools. I've no doubt, I'm very familiar with what an excellent school Alpharetta High School is. And I feel like that's a we don't need to go any further. I understand it's an excellent school and it offers excellent opportunities for any student who would attend it, and that would include SC. So I think you've made your point.
Okay, and just if with the court's indulgent here, just to as part of the student assignment committee's decision to say that it would be in the best interest of SC to remain at Alpharetta High School, are these the types of things that the student assignment committee and you had in mind?
Yes, that's correct. I think, as I stated before, the first piece that we look at is the enrollment and capacity of any kind of request that comes to us. And then we start to look at, is there any other reason why an alternative placement would need to happen for a student? And I can give you a quick example. There might be a student with special needs that needs a placement where they're going to a school that only offers the services that they need. But that was not the case here.
Okay, right, because you're talking about a student with special needs.
Yeah.
Right, okay, not here. All right, let's see, I'm not still sharing my screen. No. All right. Make sure I don't have anything else for you. Okay, no further questions, Your Honor.
Okay. I have a few questions, Mr. Maloof, and then I'll let the lawyers follow up if they have any. So help me understand more broadly. As much as I just said, I'm familiar with
Sure.
Fulton County Schools. I'm not a parent with students in that school district. How, other than what I would refer to loosely, I'm sure y'all don't refer to them as, alternative schools, right? How many schools like Innovation Academy are non-zoning schools that require a special application process or otherwise to get into?
Okay. So we call those choice schools.
Thank
And
you.
yeah. So we have two STEM focused schools. One is the Global Impact Academy, which is down in Fairburn, and we have Innovation Academy, which is up in Alpharetta. The other options that we have is the Promise Career Institute, which is in College Park. That school focuses on the uh, I always get this name wrong, and I apologize. It's the um, alternative diploma that students can get where they receive two technical certificates along with a high school diploma. So it's an advanced academics for technical education. So they do things like, robotics, engineering, things like that, and they partner with Atlanta Technical School.
Okay. And do all three of those schools have the same requirements? Like the board policies and procedures obviously would apply across the board, but do they all have the same policies and procedures for applications, enrollment, and do they all go through your committee for acceptance or admission?
Okay, so none of the schools go through our committee for their initial application process. And each of the schools has, because of their uniqueness, has a little bit different process with it. But essentially, they all go through the same kind of process to accept students. Once that process has been completed, that's when our committee would kick in. So if you're outside of their normal application process, that's when our committee works from. So that's that. I hope that answers your question.
It does. Thank you. Now, in terms of the work of your committee, where you're considering student assignment outside of the application process for a ninth grader, et cetera, as was presented here, has to your recollection, has the application committee, I'm sorry, the student assignment committee,
Sure.
considered an application like this where a student was had an enrollment break and then sought re-enrollment through the student assignment committee, other than SC?
Not for a choice school.
Okay. Um, okay. I must admit, I was a little confused. Again, I think some of the lawyers, I think, have internalized some of these facts, and I'm not as fluid with them as they are. There was a question asked of you a moment ago regarding whether you had ever received an application from SC for the 25-26 school year. I thought that's what I heard, and you indicated no. Is that correct?
That's correct. To my
Okay.
knowledge, we have not received anything for next year.
Okay. The reason I'm confused are the decisions that are being made, the applications in December, January, right, which is the application period, December 24 to January 25, and then enrollment acceptance decisions being rolled out for ninth graders, right, presumably in January of 25. That's for admission into the 25-26 school year, is it not?
That's correct. And
Okay.
that's for the freshmen.
Okay, right. And I understand she was not a freshman and was outside of the normal process. But I guess where I'm a little confused is the application that you did receive and that the student assignment committee did consider.
Mhm.
What was, to your understanding, what was that an application for?
So to my understanding, when I saw the application, when I saw what the committee reviewed, it was for essentially an immediate readmittance to the
So
school
for
for
this
that current
current
month.
school year.
Right. And for when we have any applications that come to us that are going to be outside of we're trying to get placement at this time, they would indicate something down the road. They would indicate that it would be for something down the road. And we don't usually get for the following school year during the school year.
Okay. And understanding that you can't prejudge what such an application might look like or how it might be handled, but does that then mean that SC could apply right now for placement into the 25-26 class and go through a whole nother process to be considered?
I mean, I suppose.
Okay. So there was some discussion about the policies and procedures that were adopted by the school board. Looks like in August of 2024, and then maybe reviewed or revised in December of 2024. I think that was Defendant's Exhibit A that they showed you. Do you recall what I'm referring to?
I am familiar with it, yes.
Yeah, we had lots of discussions about Mr.
Okay.
Bryan reading them and asking you to read them.
Yeah.
So,
Okay.
yeah. So the question I have is there was some discussion about the fact that the policy, the magnet school policy for enrollment for Innovations Academy
Okay.
provides that if there is a break in enrollment for any reason, that a student will not be eligible to return. But then the district policy, presumably adopted either in August or December of 2024, says that a student with a break of enrollment must reapply for admission. Do you know why there's a difference between those two things and why the board specifically adopted this new policy in either August or December of 2024?
Certainly. The answer to your question is no, I don't know.
Okay.
I'm not that close to policy making, we're more, here's your policy, go make it happen.
Understood.
That's more my role in it. If they ask me a question on, what would make sense here or there, I answer those. That's about it. So I apologize, but I can't answer that question.
No, that's fair. And I understand that that's not within your purview or within your job responsibility to follow what the processes are, what motivates it, but once it's adopted to implement it, I understand that. And I think those were all the questions that I had. Based on those questions, Ms. Waldman, did you have additional questions for this witness?
Yes,
or
thank you.
redirect as well?
Yes, thank you. Let's focus on Defendant's Exhibit A for a moment. That policy was implemented, as we identified, for the first time in August of 2024. Is that correct?
That's correct.
And there was not an equivalent policy of that prior to August of 2024?
If by equivalent you mean that established our committee, then no.
Okay, and with respect to what has to happen when there was a break in enrollment in a choice school?
Yeah, not to my knowledge.
Okay. And that policy came into effect after SC's removal from Innovation Academy? Is that correct?
I think that is correct.
Okay. And you're aware that SC's removal from Innovation Academy was not of her own volition?
Yes, but I don't really have all the details of what happened.
She didn't voluntarily leave.
Okay.
Are you aware?
I am aware that there was a reason that she left, and I'm aware that there was a discipline case. Beyond that, I'm not aware of why.
And you're aware that she's been trying to return consistently since the discipline decision?
I'm not aware of that. All I'm aware of is what they presented in the application to our committee.
And what was presented in the application to your committee included the email that we shared in Exhibit D, correct?
That's correct.
And that was to you in addition to being.
That was to our operations department. It wasn't directly to me.
Did you review that letter before making a decision?
Not in conjunction with her application.
You mentioned during questioning from Mr. Bryan that when talking about capacity, you're looking to Georgia DOE requirements. Is that correct?
That's part of the decision-making tree, yes.
You're aware that Fulton County school system is a charter system?
Mm-hmm.
What does that mean?
It means that we are able to waive certain things from Title 20 regulations. Not everything, but some.
Okay. Included in the things you're entitled to waive, does that include capacity?
If you're asking me that our buildings don't have to meet the Georgia Department of Education requirements, then the answer to that is no. We have to do those things.
Okay, but you're able to waive capacity as it relates to class sizes?
But that's on an individual classroom basis, so yes.
But Innovation Academy could apply to the board at any time to waive class size requirements?
Yes, but not capacity of the school requirements.
Okay, and when you talk about capacity of the school requirements, what exactly are you referring to?
That means how many students are enrolled at the school. A class size I'm sorry, go ahead.
When we talk about Innovation Academy, we have talked about a capacity of 1,500. Is that correct?
That's correct.
We heard testimony earlier today that at the fall of 2024, Innovation Academy had 1,524 students. Does that sound correct?
I'm vaguely familiar with that.
Okay, so that is over 1,500, right?
That's correct.
How does that happen? Like, how does that happen while you're in compliance with rules and regulations?
It doesn't.
So what are the consequences of being out of capacity?
So I think in this particular situation, the consequence of that is they need to bring themselves back into compliance with capacity through their next application process.
So there were no implications for the 24-25 school year for being out of compliance?
No.
No legal implications, I should say.
Objection, Your Honor, to calling for speculation about legal implications.
I'm gonna ask Ms. Waldman to rephrase her question.
Yeah, I apologize. I was trying to distinguish Mr. Kent's answer. There were no implications from the perspective of the board for what the board did for having been over capacity?
Objection, Your Honor. It's compound, and it is really unclear what she's asking.
I agree. You can try to rephrase again, Ms. Waldman.
What was Innovation Academy allowed to operate over capacity this year?
Yes.
I have no further questions.
Okay, Mr. Bryan?
Yeah, I'll just to clean something up real quick here. I'm going to share my screen, Mr. Maloof, and show you what's been already previously admitted as petition as Exhibit E. All right. And do you see that in front of you?
Yes,
All right, and this is the application to the Student Assignment Committee.
that's correct.
Okay, all right. I'm going to zoom in here to the top right of page 2. Can you please, does that say that this is an application for transfers for school year 2024-2025?
That's correct.
Okay, excellent. Now, let's take a step back and I know Miss Waldman had asked you some questions about waiver. About waiving certain rules. Now, and you testified that you can't waive capacity rules, right?
That's correct.
Okay, and is there a board policy that requires you to comply with State Department of Education regulations on, school capacity?
Yes,
So even if the Board of Education wanted to waive it, it hasn't.
that's correct. It's in our policy.
Got it. Okay, so the board has expressly adopted those.
That's correct.
Got it. Okay, no further questions, Your Honor.
Ms. Waldman, anything else?
No, Your Honor.
Okay, thank you, Mr. Maloof. You are excused as a witness.
Thank you.
And I must say to the lawyers, perfect timing. It's 12:14. So we're going to break for lunch for about 30 minutes. And we will resume at 12:45 with our continued hearing. Okay. Thank you all. You're free to log off. The link will still be here. You can just mute and turn off your video if you want, or you can log off and log back in at 12:45. Either one will work. We'll still be here. Thank you all.
Thank you.
Madam Court Reporter, are you back with us yet?
Yes, ma'am, I am. Sorry about that.
No, not a problem at all. It's exactly 12:45, so it's not like you're late.
I was checking emails, just looking at my other screen.
Yes, ma'am. Okay, are we ready to, we're back on the record, Madam Court Reporter. Are we ready to resume, Ms. Waldman, with your next witness?
We are, Your Honor, and we have some good news to announce.
Okay,
We took advantage of the break. The parties have stipulated to the admissibility of exhibits H and I.
okay.
For Dr. to testify.
Hang on one second, Ms. Waldman. The other people logging in interfered with your audio. The last thing I heard was exhibits H and I, and then you said something else that was
We have
muffled.
stipulated to the admissibility of exhibits H and I, and in exchange, we have withdrawn our request for Dr. Looney to testify.
Okay, so okay, withdrawn request for Looney. Okay, that I very much appreciate that, counsel. Thank you. Okay, what are we ready to proceed beyond that, Ms. Waldman? I mean, anything else besides calling our next witness?
No, just our next witness will be SC, and that will be handled by Ms. Windis. So I'm going to mute all the things so we don't echo a whole lot first.
Okay, thank you. Mr. Bryan, anything from you before we go ahead with our next witness?
I'd just like to confirm that there's nobody in the room with SC.
I was going to ask once we start that, just based on what we had discussed. Okay. SC, can you unmute your line, please?
Hello.
Hi, SC, I'm going to ask you to raise your right hand.
Oh, should I turn on my video or?
No, I'd rather you did not. We're going to go through that in a moment, but I wanted to have you sworn in before I ask you those questions. Are you ready, SC?
Yeah.
Do you have your hand raised, your right hand?
Yes.
Okay. Do you swear that the testimony you're about to give the court will be the truth, the whole truth, and nothing but the truth to help you God?
Yes.
Okay. Thank you. You may lower your hand. So SC, my name is Judge Krause, and in a moment, your attorney is going to ask you some questions in this case. What I wanted to make sure you were aware of is that in order to maintain your privacy that you are entitled to because you are a minor and a student, the parties have agreed that we will allow you, and the court has approved this agreement, to allow you to testify with your camera turned off. And that's because this is being live streamed in order to constitutionally have open courts. And so we will allow you to testify with your screen turned off, so long as you can affirm a few things for me. Number one, are you in a room by yourself?
Yes.
Okay. I assume you have a computer screen open because you're using Zoom. Want to make sure that you understand that you are not supposed to access anything else on the computer other than the Zoom screen that you're using to testify here today.
Yes, I can confirm nothing else is on my computer except the Zoom meeting.
Okay, excellent. I'm satisfied with that showing for now. Mr. Bryan, did you have any other questions, concerns, reassurances that you wanted me to put on the record?
Yes, Your Honor, could you ask the student to alert the court if anyone enters the room during the course of the examination?
Fair enough. SC, did you understand that I am going to request that if anybody does enter the room, just let me know that someone has come into the room, and we'll deal with it if it occurs, okay?
Yeah, of course.
Okay. Anything else, Ms. Waldman? Or Ms. Windis, I should say?
No, Your Honor. Thank
Okay.
you.
Ms. Windis, you may examine your witness.
Thank you, Your Honor. Good afternoon, SC. Could you please state your current grade level for the court?
I am in 11th grade.
And could you please tell the court a little bit about your educational background?
I was previously attending Innovation Academy throughout my 9th grade year and my first semester of 10th grade. Midway through the second semester of 10th grade, I was transferred to Alpharetta High School. Ever since then, I've been attending Alpharetta since.
And what are your career aspirations, SC?
I aspire to be a future licensed architect and go to architecture school for that career.
What would you like to do with your architecture degree?
I want to build animal facilities and improve animal well-being through them.
I'd like to direct your attention now to Innovation Academy specifically. You're familiar with Innovation Academy, correct?
Yes.
And why did you initially apply to Innovation Academy in your 9th grade year?
I heard Innovation Academy specialized in a STEM-based curriculum, and I want to explore specifically the engineering pathway. So Innovation Academy provided a lot of specialization in that field. Therefore, I could get an early start in the engineering pathway.
And what was the application process like when you first applied as a 9th grader or a rising 9th grader?
I submitted an essay on my biggest challenge I faced. Innovation Academy does offer students who are applying to send a video essay as well. And there was another prompt where you had to make an essay on what kind of trait of an Innovation Academy student reflects upon you.
And what was your experience like as a student at Innovation Academy?
I got to meet a lot of students who also aspire to be in the STEM fields such as healthcare and IT. And I got to contact with teachers who have specialized and practiced in those fields, specifically engineering. I got to learn a lot about various engineering fields such as aerospace, electrical, and much more. I also got to implement those skills during the Flex Fridays that they offered, and seeing many other students who also aspire to be engineers and seeing their projects is such a big impact to me. And I want to accomplish those same dreams as well.
Thank you for that, FC. Could you describe any like special programs that Innovation Academy offered or other educational opportunities that you'd like to highlight for the court today?
As mentioned previously, Flex Fridays give a chance for students to learn more about the pathway they're in. I got to attend the Engineering Flex Fridays where we get to explore different skills in different engineering fields. For example, I got to attend the drafting class. I also got to explore new things about different engineering fields. For example, at the Cosmic Odyssey, I got to participate in the cooking event about NASA astronauts and what they eat during space. And I think that's really impactful to me because engineers also have since engineering has so many aspects, it helps me learn about well-being as well in that pathway.
And one thing so Flex Fridays are part of the requirement for the magnet school curriculum from Innovation Academy, as I understand it. And another thing that's required is for students to select career pathways. Is that correct?
Yes, they are allowed to select their own pathways.
And your career pathway, what discipline was it in?
Engineering.
And what is entailed with being in an engineering pathway?
Could you repeat that, please?
Yeah, I'll make it a little bit clearer. What's involved with being in an engineering pathway as a student at Innovation Academy?
There isn't anything specific about the engineering pathway. We learn various aspects of the engineering field. For example, we got to learn isometric and orthographic drawings, which is just different views of an object and
Thank
how
you
to
for
draw them
explaining
on
that.
paper. Hmm?
I didn't know what either of those things were, so thank you for explaining that, SC.
Yeah, of course. I also got to learn how to program an Arduino, which was really fun. Even like making it play songs was a great experience. I also got to meet, also connecting with other teachers who have practiced in those fields. I am aware that there are multiple engineering teachers at Innovation Academy with different experiences in different fields, and those connections from them have helped me a lot with exploring new opportunities.
Thank you for explaining that. I appreciate that. Another thing that Innovation Academy requires is that students complete something called a Pinnacle project, as I understand it. Can you tell us a little bit about what a Pinnacle project is and what that would look like for a student who was in the engineering pathway?
Yeah, the Pinnacle project isn't, as from what I'm understanding, is not based solely on your pathway, but based on the research class you're taking as a junior. So, for example, my sister takes the scientific research class at Innovation Academy, and she's doing research on biodiversity in kimchi, which finds which kind of kimchi is the most biodiverse. And this helps people in the culinary field and also medical field on what's better.
And I'm going to move on from the magnet requirements. You did a great job answering all my questions and ask you a little bit more about how your education changed after you left Innovation Academy. So how did your education change after you left the school?
Student environment was a big thing that changed. Um, since Innovation Academy is full of students who have clear goals on what they want to achieve, Alpharetta High School does give you the chance to explore many new fields, but many of the students there don't have any, in the nicest way possible, not many passions or any direct goals they want to achieve at this point in their life. And being around people who haven't taken it seriously, is that kind of environment is something I don't want to aspire to be in, because as a person myself who wants to be around people to achieve their goals, and as someone who wants to, I don't think that kind of environment was very easy to adjust in. I also want to clarify that there's only one engineering teacher at the school instead of multiple. So it was hard to find advice on specific things, and for example, my engineering teacher doesn't understand AutoCAD, so it's difficult for me to find advice like that in person when I need to.
Thank you for the specific examples. Why do you wish to return to Innovation Academy?
As mentioned previously, I want to go back to the student environment, and I also want to take the research design and project management class there, which is what seniors take at Innovation Academy as their last class in the engineering pathway. And I also want to, and since I'm aware that Innovation Academy has many business partners in the STEM field, I want to take advantage of that opportunity and make sure I also get to explore more about the architecture field through that.
And could you give some examples of some of the things specifically that you'd wish to explore, the opportunities that you might be able to get at Innovation Academy?
Yeah, so for example, research projects, from what I understand, you need to take a research class in order to graduate from Innovation Academy. They have many research opportunities at Innovation Academy that Alpharetta High School doesn't. So I'd like to pursue a research project, especially in architecture, and put that on the showcase and build in some knowledge of the architecture field.
Okay, thank you. Is there anything else you'd like to share with the court?
No, thank you.
All right, thank you, SC. I have no further questions at this time.
Mr. Bryan?
No questions.
Okay. SC, you hang on one second. SC, I do have a question. The basic request here from your counsel on your behalf is to seek reinstatement to the Innovation Academy program. And one of the things I've heard from some of the educators that I've heard from in this case is the difficulty that they would expect you to have in resuming the coursework there, resuming your education there, having had such a long break. Have you given that thought in terms of how you will be able to make that adjustment if you were to be granted your request, right? And whether or not that plays into your consideration.
I have thought about it for a long time on the coursework of transferring to Innovation Academy and adjustment there. Since I have attended Innovation Academy for my for almost 2 years, I'd say I'd be able to adjust it pretty fine, especially knowing plenty of people at Innovation Academy that can help me. If I'm not sure if you've looked at my transcript, but I was able to manage all the classwork there when I was attending as a freshman.
I have seen, I think in a prior iteration of this case, your transcript was in evidence, and I did review it and was, I am aware that you were a very impressive student, probably still are, albeit at a different school. So thank you, SC.
Yeah.
Ms. Waldman, or I'm sorry, Ms. Windus or Mr. Bryan, do either of you have any questions based on that question?
No, Your Honor.
No, Your Honor.
Okay, SC, you are excused from being a witness. You're of course free to remain in the hearing and observe the rest of it as you've been doing so far. Ms. Waldman, you may call your next witness.
No further witnesses, Your Honor.
Okay. Mr. Bryan, does the school district wish to offer any witnesses?
No, but we'd like to move for a directed verdict at the appropriate time. I don't know if you want to go ahead and get into that now, or if you want to do closing arguments and then go for directed verdicts, however you'd prefer to proceed.
Well, I feel like now would be the appropriate time for a motion for directed verdict. The evidence is closed. And so if you want to move for a directed verdict, then why don't you tell me that now?
Okay, Your Honor, we move for directed verdict because we do not believe that the petitioners have established a clear legal right to relief under mandamus. Now, I'm not going to, well, most of these are legal arguments, Your Honor, and I do not want to belabor the point. We've briefed a lot of these legal issues and discussed them extensively. Of course, we move, for a directed verdict on res judicata. I believe both the filings that have already occurred in this case, plus the testimony shows that this is not an action that arose after a previous, or that to the extent that the court's ruling on res judicata, that this is a different case because it arose after the underlying right arose after final judgment in the previous action. I'm pretty sure we can say now that that is no longer the case. We have even like I said, the most recent brief from the petitioners in this case say that sort of the abuse of discretion here, the denial of SC's application stretches all the way back to February of 2024 and her right to attend Innovation Academy. And of course, that is long before the litigation in the prior case. And so to the extent that this court's ruling is based on a finding that the claim accrued after the previous litigation and what we've been calling FCSD1, I'm pretty sure now that is it's pretty clear that's no longer the case. But otherwise, I'm just going to repeat, I'm just going to incorporate the previous arguments on summary judgment. And I do believe that this action is barred by res judicata. Now, as it concerns the mandamus standard itself, we have not shown, the plaintiffs have not shown that they were denied a full and fair opportunity to be heard on their claims. Due process is about process. And we have to ask, what process were they denied and what process have they showed that they were denied? There's no process. I mean, they were granted, of course, a ton of process. We already know that. And the federal due process clause says all that due process requires is a full and fair opportunity to be heard. And there's no suggestion that they have not had a full and fair opportunity to be heard at any point along the way. I'd point the court's attention to Shields versus Bell South Advertising, which is an 11th Circuit case 228 F.3D 1284. In that case, the 11th Circuit goes into a discussion of what due process requires when someone has already gone through a previous administrative process. And of course, that is the full and fair opportunity to be heard standard, and they discuss it there. I've had my own, this has come up in some of my own previous cases, specifically Sheba versus DeKalb County, Georgia. It's another 11th Circuit case, 820 Federal Appendix 889. It is an unpublished case, but it dealt with a similar issue. There was a due process challenge saying where the plaintiff was saying that they were denied due process because they didn't achieve the result or the final relief that they wanted in a previous case having to do with a license revocation. And the 11th Circuit said, no, you got plenty of notice. You had a full and fair opportunity to litigate those claims in your previous, in the previous administrative action and in Superior Court, and therefore you were not denied due process at all. So there is no underlying due process here. We also can see that there is no property right to begin with for her continued enrollment at Innovation Academy. I mean, we see that at least prior to August of 2024, there was a policy at Innovation Academy specifically stating that a break in enrollment for any reason, students would not be allowed to re-enroll after a break in enrollment. So at the very beginning of this, there is that shows that there is no absolute right to attend a school of your choice after a break of enrollment. And that is in the record. That is part of a policy, and we heard testimony about that. Beyond that, there is no right under Georgia law or under the Georgia Constitution for continued enrollment at a particular school, so long as a school district provides a free and adequate education. It is in full compliance with its constitutional duties. And not only is the Fulton County School District in full compliance with its constitutional and statutory duties, but actually it's educating her at one of the very, very best schools in the country. And I understand that the student would prefer to be at Innovation Academy, but in no way, shape, or form can we say that she is being denied a good education. She's being provided one of the best educations she could possibly get. And so those are and then of course, I mentioned this before in opening arguments. There is a policy. The evidence shows that my clients complied with a policy that requires an application through the Student Assignment Committee for anyone that is currently enrolled at their zone school and wants to go to a different school. And that is that policy is binding on administrative officials. My clients testified that they operated in complete compliance with it. There's been no challenge to that there's been no challenge to that policy. There's been no challenge saying that policy itself, would otherwise violate someone's due process rights or violate any other right, nor could they, because, or at least they couldn't through a mandamus action, because the Georgia Court of Appeals and the Georgia Supreme Court have both said that mandamus is not the proper vehicle to challenge the constitutionality of a local policy. And again, I'd point the court to the Carson v. Brown case, which I mentioned earlier, and the Supreme Court case, the Georgia Supreme Court case. And I'm sorry, I can go ahead and pull that up for you real quick here. I'm sorry, I should have had this already. Harper versus Burgess. That site is 225 GA 420. And it's a 1969 case. So this has been around for a while, and it's been applied by the Georgia court since then. So there is no challenge to the policy. The policy is valid, and my clients complied with the policy. There's no abuse of discretion there. There's no clear legal right for her to attend Innovation Academy under the laws and policies that currently exist. And then finally, I'd like to go ahead and move for a directed verdict on attorney's fees. To the extent that these claims are asserted against the school district, school board, and the individual respondents in their official capacities, they would be barred by sovereign immunity. And to the extent that these claims are asserted against the individual respondents in their personal capacity, they would be barred by official immunity, which deprives superior courts of jurisdiction under judgments against public employees, including school employees, for the exercise of their discretionary duties unless there is evidence of actual malice, which means an intent to harm somebody on purpose with malice. It is a very high bar, and there's no evidence in the record to suggest that anyone acted in malice here. And then, and so that is, we move for a directed verdict on those grounds.
Thank you, Mr. Bryan. Ms. Waldman, your response to the directed verdict motion?
Yes, Your Honor, we'd ask that you deny the motion for directed verdict. The issue of res judicata has been litigated, I would say, to death. Your Honor has issued a final ruling on that. I ask that you stand by your initial ruling with respect to res judicata. My only very brief responsive legal argument, the cases cited by Mr. Bryan are just quite frankly inapplicable to the setting that we have here. What we have here, as Your Honor is well aware, because you heard the original case, is a case where we were confined to the record under 20-2-1160. That statute, the Public School Disciplinary Tribunal Act, specifically says you can't make new arguments, you can't make new claims. You are bound by the actual statute itself, which was the statute that Mr. Bryan and respondents themselves utilized to bring an appeal to you. And Mr. Bryan knows that to be true because he told you that, or actually Ms. Akins told you that at least a dozen times in the underlying action when they said you have three choices: affirm, deny, or remand, and solely those three choices. We agreed at that point that it was not appropriate for us to issue a counterclaim, that is something that would wait as a natural remedy, hoping that the natural remedy of return, which has always been known to be the natural remedy for an illegal disciplinary proceeding, would in fact happen as a result of that. SC went through the process as many times as they would let her. She applied when they told her to apply. She went through a transfer when they told her to transfer. She did all of the things she could possibly do to effectuate what is the natural remedy of her overturned illegal, arbitrary, and capricious disciplinary decision. For those reasons, res judicata is inapplicable, as well as for all of the reasons at the underlying hearing and as issued by your prior court order. On the merits motion themselves, I will start with the easy part. We are not challenging the constitutionality of the student assignment process. I will note that that process came about on August 1st, 2024. Your Honor rightfully asks why. Timing is interesting, is what I will say. And it is exactly as SC was trying to return to school as a result of an illegal discipline process. They wrote a policy that prohibits her from returning to school as a result of an illegal discipline process. We can draw our own conclusions, and I will let you do so. That said, that's not the argument. It has never been the argument that the policy is a bad policy. The argument is that you don't get to benefit from your illegal actions. And that's an argument, and that's a rule that has been around since the beginning of time. No, we don't have a lot of cases on charter schools. It doesn't come up that often. Not on charter schools, I'm sorry, on choice schools. It doesn't come up that often. Magnet schools don't come up that often. There aren't a lot of suspensions followed by overturned suspensions, followed by students trying to come back, followed by denials of that right. The case law is non-existent. If I found it, you'd have it. If Mr. Bryan found it, you'd have it. It's just not there. This is a somewhat novel application of a completely not novel rule. SC was legally enrolled at Innovation Academy. She was illegally removed.
Sorry, forgive me for interrupting you, but I think it would be helpful to me if I could ask you to skip over this part for a moment. And the reason is that, to me, that is the crux of why we're all here. And that's ultimately the decision that I have to make, whether it's on a DV or whether it's based on the evidence that I've heard. I believe the res judicata made sense for you to go ahead and address it. I'd also appreciate it if you would address Mr. Bryan's arguments regarding attorney's fees. And then I think it would be helpful to sort of go backwards to the property interest due process issue.
Sure. I don't care about attorney's fees. This case has never been about attorney's fees. We haven't briefed it before. SC wants to go back to school. If we have to go to a 1983 action because there is a continued denial of her right to go to school, 1983 comes with a provision that entitles me to attorney's fees, and I will ask for all of them there. I am happy to, have always been happy to not charge attorney's fees if they do the right thing. I think a mandamus is perhaps not the right vehicle for an attorney's fees action. I think that will be appropriately provided for in the 1983 action that is to follow.
Okay.
I just want to go back to school.
Okay. So just to sort of bring us back around to where I think we need to be,
Mm-hmm.
and again, forgive me for interrupting you, Ms. Waldman, but I do not intend to revisit my ruling on res judicata. As a side note, Mr. Bryan and Ms. Akins, I did want to let you know that my staff attorney did some research while we were all here to figure out what happened. We don't know the answer to how it happened, but it is not your imagination. You were not served with a copy of my order that was filed. As I suspected, we've asked Tyler Technologies and eFile Georgia and the clerk of court to do some investigating to see if they can give us an answer. But for some reason, when Mr. Freehoff e-filed that document, it is supposed to grab all the service contacts. Y'all are all there, including a couple of extra from Parker Poe. And for some reason, it only grabbed the people associated with the petitioner, and I don't know why. So I want to let you know that, particularly given that what I'm saying is that both the verbal ruling and the written order that I subsequently entered, I believe that the requirements of res judicata have not been satisfied to foreclose the nature of the relief that is being sought by SC. And so for that reason, Mr. Bryan, the motion for directed verdict on that issue is going to be denied. And then as to the attorney's fees, the motion for directed verdict, it's either going to be granted because she's not entitled to them or denied as moot because she's withdrawn them. But the point is, it does not appear that SC is any longer pursuing and seems to tacitly understand that in a mandamus action, they would not be allowed in this particular procedural vehicle. And so that leaves us with the substantive issue that was previously the subject of your motion to dismiss. Obviously not outcome determinative, because all I said at the motion to dismiss was that the petitioner had asserted facts about whether there was a due process violation or a property interest that, if proven, right, there was a set of facts based on those allegations that might get us there. And so that's where I think we are now. And for the same reasons that I denied the motion or excuse me, that I denied your motion to dismiss, I'm also going to deny your directed verdict motion on that issue, because I think there's enough there that I need to make a substantive decision based on the evidence that's actually in front of me, rather than a determination that some element that the petitioner would need to demonstrate has not been supported by some facts. Now, whether I find those facts persuasive or not is the heart of the matter. And so that's what I'm going to do. So I think that's a very long-winded way of saying your motion for directed verdict on res judicata is denied. Your motion for directed verdict on the property interest / due process argument also denied. And we're going to say that your attorney's fees motion is granted. And we'll move on we will move on. Actually, I think I'm going to deny the motion for directed verdict on attorney's fees as moot, because Ms. Waldman has withdrawn the motion, I think is what I'm going to do. And so that's going to be my ruling on your motion for directed verdict. And so now what I'd like to do is move on to closing arguments regarding the merits and substance of the case. Anything else you want to put on the record, Mr. Bryan, before we do that?
Yeah, I guess I just want to, and this is something that we just really actually haven't addressed at all. And maybe you addressed it in your, in the order that I have not fully digested yet, but there was 2 claims. One of them was for readmission to Innovation Academy, and the other one was for expungement of a record.
Yeah, we had not discussed it here. Your briefing, I didn't rule on that issue substantively because to me, the relief was really the open question. The issue was there a cause of action from which any of that relief could flow? And so I did see that your position in your briefing is that because her record, Ms. SC's record has been expunged, that aspect of the relief sought by the plaintiff is moot. And I don't believe that I ruled on that issue, again, because it was a remedies issue rather than is there a cause of action from which those remedies might flow? And that was what I was focused on in that order. So.
Okay. And so I guess, it seems to me that we're all in agreement that that issue is moot, or are you saying that it's still a live issue?
I believe, I mean, I don't recall specifically the nature of the request for relief in the petition. I certainly recall much discussion regarding whether or not expungement had been requested, whether it was something that was allowed. I specifically remember a case to which everyone had directed my attention regarding the issue of expungement. And so when I did not address it in my order, because again, I was focused on causes of action, not remedies. But to your point in your brief, under your trial brief indicates, and I agree that because if it is in fact correct, as represented by the Fulton County School District, that her record has been expunged of that discipline, then that would make moot the request for that remedy. Ms. Waldman?
We would agree that it is moot. We have been provided evidence that her record has been cleared, and so they have complied with that in advance of this hearing.
Okay. Mr. Bryan, anything else before I hear closing arguments from Ms. Waldman that I really functionally interrupted about 20 minutes ago? But
no, anything else I have to address, I'll address it by own closing argument.
yes, sir. Ms. Waldman?
Yes, Your Honor. I'll start with a simple concept. Process without any evidence is not process at all. Mr. Bryan would like you to believe that she had hearings and therefore she was provided with due process of law and therefore there's nothing left to determine. And that's just simply not true. Where we are now is that the Fulton County School District or Innovation Academy or the board or any of them as a collective are trying to benefit from their illegal acts. SC attended Innovation Academy. She abided by the terms of their magnet agreement. She abided by the terms of the student code of conduct. And you heard from Mr. Kent that those are the ways you get to be removed from Innovation Academy. They removed her illegally. An illegal removal is not process. It's as simple as that. And they don't get to benefit from that lack of process. If that were true, as I started in my opening, they could arbitrarily remove any student from their school at any time for no reason at all, slap a hearing on it, lose forevermore, and still get to live out the benefit of the arbitrary and illegal removal. That's not the way this works. And that's not the way this works for a lot of reasons, right? So I'm going to go through kind of our brief, but hopefully in much shorter form, because our brief will stand on its own. Mr. Bennett identified in opening that mandamus is not the appropriate remedy for what we're seeking. It is exactly the appropriate remedy for what we're seeking. Mandamus requires petitioners to have exhausted all other remedies. We have done so. We have gone through 20-2-1160. We've tried in good faith to follow all the procedural hoops that Innovation Academy has laid out for us. And importantly, mandamus or 1983 tells us you must go through mandamus before you can get to 1983, right? Mandamus tells us that it is an available remedy at law when there are no other remedies at law. There's nothing left for her to do. Sure, she can seek a 1983 action, but she has to exhaust her remedies, including mandamus. And the only way she gets to go back to Innovation Academy is if Your Honor tells respondents that they have to let her back in at this point, because there's nothing left for her to do to exhaust. Which brings us to whether she has a clear legal right. Her clear legal right stems from multiple sources. She has attained a property right to attend Innovation Academy through 3 separate independent sources. Source number 1, the Public School Disciplinary Tribunal Act, 20-2-753. Apologize. Most of my work is in juvenile court, which is 15-11, which is where my brain automatically defaults. The Disciplinary Tribunal Act tells us that you get to be removed for cause when you violate a school code of conduct. We have already determined she did not do so. From there, we have the code of conduct itself. The code of conduct sets forth a series of expectations. The expectation is that if you don't violate the code of conduct, you get to continue to go to school, right? That's why we have hearings. And then we take that one step further and we have the magnet school requirements that come out of Innovation Academy. Taken together as their 3 parts, Tribunal Act, Code of Conduct, Innovation Academy's magnet school requirements, which have some additional requirements around gifted and talented programming and attendance and things like that. And you get, again, an expectation of a property right to go to school that looks very much like the right that we talked about in Barnes at our last hearing. Barnes started with a statute. It followed up with a code of conduct, and it resulted in the natural remedy of the violations of those things being a return to school. At our last hearing, Mr. Bryant tried to tell us that the remedy is a return to a Fulton County school, not Innovation Academy specific, because there's nothing different or special about Innovation Academy. We heard today that that's not true. We heard that from Mr. Kent. We kind of heard that from Mr. Maloof. We definitely heard that from SC herself. Innovation Academy is special. It was designed to be special. It is not like every Fulton County school district. As wonderful a school as Alpharetta is, it's not the same. Innovation Academy has its own philosophy. It has its own curriculum. It has its own application process. It has its own magnet school requirements. It is a thing that is different. It is one of 3 of those things in the entire county. And each of them are slightly different, but there are only 3 schools in Fulton County that were identified as STEM-related choice schools with application processes that are not your traditional zone school. SC complied with everything she can comply with while she was at Innovation Academy. She attended the Gifted and Talented program. She attended Flex Fridays. Her attendance record is in the record, for your honor, in this hearing, as is her transcript from prior to her removal. She was in compliance with the magnet requirements. She was in compliance with the code of conduct, and therefore her removal, her illegal, arbitrary, and capricious removal, was a deprivation of the property right that she acquired while she attended Innovation Academy. I think that is the easy part. We then move to remedy, right? Once you have the deprivation of a right, we go to remedy. The remedy in every context that has been considered by courts forever, I could go back to the Chancery courts, has been that when you have a deprivation of a right that has been violated, the natural result is that you get to return. And this has come up in all sorts of contexts. It's come up in school discipline contexts, although admittedly not in the context of a charter or of a choice school or a magnet school. But it has come up in the concepts of discipline, right? It comes up in the concept of Goss v. Lopez to begin with, which is, right, we have due process rights that get us to property rights, and the cases that come from that say the result is when you win, you go back to school. Probably the most there is a case I'll draw your attention to that is in our brief from the 6th Circuit, admittedly not an 11th Circuit case, which is Newsom. 842 F2D 920 from 1988. Newsom doesn't decide the question itself, but it does talk about the fact that reinstatement is perhaps an option, right? It is a preliminary stage in the case, and it says, to the extent that Newsom seeks reparative relief aimed at restoring him to the position he would have occupied but for the due process violation, he is entitled to such relief unless the school district can prove by a preponderance of the evidence that even had it not deprived Newsom of his right to procedural due process, he would have still rightfully been expelled. Right? There has been no indication at any point, and witnesses have been asked directly, that SC would have been removed from the school but for this illegal removal that was at issue in the first case. That is quite honestly the closest case on point that talks about return for an illegal removal in a school discipline process. The most relevant cases are probably, or the most next relevant cases are probably in the teacher removal context. And there are a number of cases in the teacher removal context. And what they say first on the property right issue is that even absent tenure and even absent contracts, you may maintain a property interest in your right to be not fired other than for cause, or not even issued a brand new contract when your contract has been expired other than for cause. And then when you have been illegally not offered a new contract, you get to go back and re-obtain your position at the school that you had been fired from or had not been rehired from. Those are probably the most relevant cases, but there are cases in employment. There are cases in licensing. There are cases in bond hearings. There are cases in criminal convictions. We provided you with very long string cites in our briefs. I will not actually go through each of them because I think the two that are most relevant are the two that I have provided you, which is the but-for analysis. That analysis, I will tell you, comes from a Supreme Court case. Again, not necessarily about reinstatement, but it is a derivation of cases from Carey v. Pifus, P-I-P-H-U-S, and that is, I'm going to get you a site in a second. I will come back to a site for that because it is not in my notes. Miss Windus is going to provide me that site in a second. Which is really a but for analysis that the Supreme Court has given us, that Newsom followed. There are multiple other cases in other circuits that follow that same but for analysis. Those, again, generally show up in our very long string cite in our brief. Nope, thought I was getting a site. Just typing. Uh, 435 US 247 is that site. So to conclude, right, I will come back. She has a property right. That property right was violated when she was illegally, arbitrarily, capriciously removed. Mandamus is the appropriate vehicle by which to obtain a remedy for that deprivation of the property right. There are no other remedies at law. There are mandamus cases dating back from the early 1900s. Again, we're going back a century, that talk about mandamus being appropriate remedy to return to school. And everything else that we talked about in this hearing, capacity issues, quite frankly, are red herrings. SC never should have had to go through the student assignment transfer process. SC never, I understand there's a process and that process exists when a student has voluntarily removed themselves from their school, or when a student has been removed from the school for reasons other than illegal ones that have been effectuated by the district itself. Medical issues. We heard about that from Mr. Kent. That was still a moment where the student was withdrawn from school, left of their own volition or through things that were not the fault of the school district. And yet, despite their own policy, they didn't make the student go through the process and they let them re-enroll. I understand that SC's removal has now been 1.5 years, but whose fault is that? SC tried to go back all the times she was removed. She appealed immediately. She won. She tried to come back again. They denied her. She won. She tried to go back again. They denied her. This could have been a 6-week removal that looked a lot more like the removal for the medical student that Mr. Kent talked about, where they didn't even make her go through the process. I withdrew my medical application, but it's hard to not call this malicious at some point. The capacity issues, we did not get a solid answer on where 1,500 comes from, whether there is a statute that mandates 1,500. We have not been provided with a statute that mandates 1,500 or a policy that mandates 1,500. We know that they can go over 1,500. We know that they are currently, well, as of the fall, they were at 1,521. As of January, they were at 1,501. We also know that there is attrition along the way. Again, it's unclear. Mr. Maloof couldn't tell us what a wait list looks like. Allegedly, SC was placed on a wait list. We know from Mr. Kent that there's attrition of 11th graders and they never accept another 11th grader. Theoretically, SC's original spot in the size of her classes should still be there because they've never accepted another 11th grader. He told us that, which means we're not talking about creating a brand new geometry class because our 9th grade class got too big. So maybe we're talking about the number of students in a building, which is somewhat flexible because we've been over that number. But also if we're looking at the fall, which we are now, SE tried to come in before all of these issues, right? Before they accepted any incoming 9th graders, they could have saved her spot. If she was on a wait list, I'm not really sure what that means again, but they could have saved her spot. She could come right off the wait list right now. If we really wanted to, we are using capacity as an excuse to say we're not ready to allow her to come back because we believe our discipline was right and we wish to stand by our discipline.
I object to that, Your Honor. I'm sorry. That is complete mischaracterization of the evidence. None of that came up.
Your objection's overruled. I understand that to be argument based on facts that are in evidence about the decisions that were made and how she wants to characterize why those decisions were made. And so I'm going to let her make that argument. Go ahead, Mrs. Waldman.
This feels like retaliation. This looks like retaliation. This looks like we know that her discipline was overturned, but we don't wish to do anything about that. We will not do anything about that. We will dig our heels in and say, we don't care what it looks like on paper. You're not coming to our school. The capacity argument is a red herring. The transfer assignment process is a red herring. The issue in front of you is does she have the right to go back? If she has the right to go back, Your Honor should order her to go back. I'll one additional note on capacity, Mr. Maloof alluded to it. It is in the exhibits that were introduced after the break, which is that the Fulton County school system is a charter system. That means they are not bound by the vast majority of the rules that are implemented by the state Board of Education. They are permitted as a charter system to issue their own waivers. That process, they have flexibility with respect to essentially things that cannot be waived are things like discipline. You must follow the due process of law with respect to discipline. You can't be waived from that. Violations of equal protection, violations of law are things that can't be waived. Class size is something that can be waived. Mr. Maloof told us that is the consequence of being a charter system. So again, if they wanted to allow SC to return to their school, there is no impediment to doing so. Your Honor can order that. Your Honor should order that. The dictates of law require that she be ordered, that the school district be ordered to permit SC to return to the Innovation Academy for her rightful place to conclude her senior year of high school. Thank you.
Thank you, Ms. Waldman. Mr. Bryan.
Yes, Your Honor. I don't see a clear legal right anywhere. And I'm trying to find it. We heard a lot of discussion now of where this supposed clear legal right comes from. And it's really a whole lot of semi kind of relevant sounding laws, statutes, and cases that are sort of trying to be like assembled together like puzzle pieces to try to create a clear legal right. But clear legal rights are just that, they're clear. They're set forth in a statute or a constitutional provision. They are not cobbled together through the Public Discipline Tribunal Act, which of course says nothing whatsoever about a right to reinstatement. Code of Conduct says nothing about reinstatement. Case law from other jurisdictions, I mean, not even this jurisdiction, we're having to reach out of other jurisdictions and draw inferences from there. From employment cases, from all these different all these different types of rules, types of regulation, types of laws, different jurisdictions, and we're trying to cobble all them together and say that creates a clear legal right. There's nothing clear about it. There's nothing clear about it at all. And that is and that's especially true when you consider the tension between the purported property interest created by a code of conduct with the other board policies, right? Like the code of conduct, they're saying creates an expectation and therefore creates a property right for continued enrollment at a particular school. But obviously that's in tension with for example, the Innovation Academy's enrollment policy, that it said right on there that a break of enrollment for any reason, you can't be re-enrolled after that. It says for any reason. Okay. And so right there, there's this conflict, and that's provided to all the students. So you've got, at minimum, you've got a code of conduct that, I don't know, I suppose some people could read in a way to think, maybe I have a right to continued enrollment. In light of this code of conduct policy, as long as I don't do anything wrong or violate the rules. But of course, on the other hand, you've got this one that says if there's any break in enrollment at all for any reason, then I'm not going to be able to come back. So that right there shows that there isn't an absolute sort of right to continued enrollment throughout someone's school career. And then of course you have to weigh that against the policy. You do have to weigh it against the policy. The policy right there. And of course, board policies are, they control over anything else, any other type of policy within a school. And the board policy specifically says that if you have a break in enrollment for any reason, you have to reapply. There's nothing clear about, there's no clear right to skip that process. There's no clear legal duty for my clients to not comply with that, with that policy. And so when we sort of cobble together, all these, like, we even admit that there's no case law point here, so we can't say that case law makes that clear. Constitution doesn't make that clear. Georgia statutory law doesn't make that clear. At best, you have conflicting evidence between local board policies, and you have one board policy that makes it quite clear that that there is no right to continued enrollment after any break of enrollment whatsoever. And so the idea that this right for her to attend Innovation Academy is clear enough to warrant mandamus is, frankly, it's not convincing. At best, it is it's a smorgasbord of one little morsel from here, one little morsel from there, and hoping we can squash this together and make a pie out of it. But we need clear law. That is what you need in order to grant a petition for mandamus, or a writ of mandamus, I should say. You need clear law, and there's just not clear law here. It's muddled law at best. And in fact, actually, when considering the policies, there is no clear legal right to continued enrollment at Innovation Academy. Now, I would like to mention something about the timing of this, the timing of the policy, the Student Assignment Committee policy. I mean, we all agree that the Innovation Academy's policy initially was that a break in enrollment for any reason is, creates a scenario where that student can never come back. Of course, we also heard testimony that they did make exceptions for that for short periods of time. For the main example here was for a medical issue. But then, then first of all, that all that predated the board policy, right? And so now we have a scenario where a board has come in, which of course has purview over Innovation Academy, and at best, implied by passing this new one that Innovation Academy, we are now overruling that whole like absolute bar, right? There's an absolute bar for any break in enrollment. Students can't go back. We understand that's your policy, but we're actually going to make it more flexible. We're going to make it actually friendlier for people that are in SC's position. We are going to give her the opportunity to reapply, and as long as these capacity issues are, would otherwise allow it to happen, you can do it, right? So this policy is more permissive and better for SC than Innovation Academy's old policy. So the idea that you would infer from that some sort of malice or some sort of retaliation when they've actually made it more likely and provided SC with an actual path to get there, assuming that there's room for it, is I think it actually cuts exactly the opposite way. Now,
Mr. Bryan, I'll save you a little bit of trouble. I'm not willing to accept from Ms. Waldman's characterization that this was retaliatory, et cetera, against SC. Now, that's not the same as saying it might have been a little reactionary to the circumstances that created SC's situation, but you don't need to defend the school and say that they weren't, that this wasn't intended to be retaliatory or whatever, because I don't think that it merits going that far in terms of what Ms. Waldman has characterized. I mean, it's a newish school. It's a newish issue. It's a newish procedure. And there are obvious reasons why that procedure might be relatively new. Its timing, I think, is relevant, but I don't think that even if I were to say it was reactionary, I don't think that it necessarily follows that it was intended to be retaliatory or specifically intended to target SC. So you can move on from that spot.
Okay, I appreciate that. And just to put a final point on that, right? I mean, if there was no evidence that was brought out during the hearing at all. I mean, there's no examination questions of the Fulton County's, witnesses about that. But in any event, I will move on to your point. Now, one thing I also wanted to address is that this whole like capacity issue is just a red herring. And I mean, that is, well, that's just not true. All right. I mean, obviously it's right in the policy. Staffing capacity of the school is in the policy, and the Student Assignment Committee is required to consider that. So right off the bat, we know that is not a red herring. It's a very clear requirement. And you heard testimony from Mr. Kent and from Mr. Maloof about why those are important, right? I mean, you even heard Scott testify that he was involved in this from the very beginning, before there even was an Innovation Academy. From the very beginning, they designed this school, worked with the architects, worked with the designers specifically to create a building for 1,500 students. That is not arbitrary. That is not capricious. That is not a red herring. It's very important. Now, it is true that they have exceeded that before, and it was a mistake, right? You heard Mr. Kent say that was a mistake. They miscalculated. And you also heard him explain why that created a lot of problems for Innovation Academy, and why after that he had to get the school back down to size, right? You also heard Mr. Maloof explain that it was a problem that they accidentally left in more. That was an error. They allowed too many students in, and it created a lot of problems. It is perfectly reasonable for a school district that made a mistake, that has too many students in it, that it's over capacity, that when they finally get back down to capacity, and by the way, almost all of the students that, Scott, Mr. Kent did testify about this, almost all the attrition happened almost immediately. Why? Because it was creating a chaotic situation in Innovation Academy. And so when they got back down to that number, I mean, the idea that it was like, okay, well, there was a mistake before, too many students were in there, it caused a lot of problems, we're back to where we are at capacity. It is completely reasonable for a school to want to maintain that capacity and not start heading in a direction where where it goes back over capacity again. It was a mistake, and it was a mistake that was corrected. And then here's the other thing. I mean, if let's just say the student assignment committee is like, well, what's one more? Right? Well, of course, then everybody that's on the wait list, well, what's one more for this student? What's one more for this student? What's one more for this student? Of course, you find yourself in a situation where then you are exceeding, you're creating, large overcapacity issues. And this is what school officials have to weigh. These are complicated decisions. And this is exactly what school officials have been vested with constitutional discretion to decide. We cannot pretend that no time passed between the disciplinary decision that was overturned and today. We live in the actual world today. The actual world that we live in is that SC has been at Alpharetta High School, and Innovation Academy has moved on. And things have happened in the meantime. And so to pretend that none of that ever happened, and to say that the school officials are not allowed to consider what they consider to be a student's best interest, what they consider to be in the school's best interest, that's just that they're not allowed to consider any of those things. It's an abuse of discretion to even consider the very real facts on the ground, and the constitutional authority they've been vested with. I think it's a bad argument, and I think it really ignores what the constitutional discretion that has been invested in my clients. Also, let's see here. Okay, so in any event, I guess a lot of my other arguments are ones that I've already made today, so I don't want to belabor the point. I think we've all done a pretty good job of being efficient here today, which I appreciate that. I appreciate opposing counsel for being efficient. I appreciate the court for moving this case along and getting to the end here. And I would just like to say that, Your Honor, when you're thinking about whether there's a clear legal right here, you really have to ask yourself, is it clear? Or am I going to have to sort of, create a new one based on sort of implications from a lot of other cases? And I think
to that point, Mr. Bryan, I do have a question for you on that issue.
Sure.
So Ms. Waldman seems to concede that because this is a school choice issue, that none of the cases squarely within the student attendance at school is directly on point, that nobody can seem to find any. And her point specifically to you, if she had found some, you would have brought it to my attention. If you had found some, you would have brought it to my attention. So one is, do you agree with that assessment? Obviously, I understand you might make different arguments about what the existing case law does say and its application here. But one, can we agree that there isn't case law specifically as to a school choice situation where there's been a particular admission to a particular school, number one. And then number two, because of that representation, Ms. Waldman has directed the court to, I know there are employment cases, loosely speaking, but teacher cases where teachers' contracts are terminated or teachers are removed from the classroom. And obviously, I deal with a lot more of those types of appeals than I do with student appeals. But to your way of thinking, my two questions are, one, do you agree with Ms. Waldman that there aren't specifically cases on school choice? And if you disagree, tell me which ones you're pointing me to. And two, to your mind, why would the teacher cases not be instructive or at least persuasive?
Okay, I guess I'll take that and I'll try to address that in two parts here. I mean, I do agree that there is no case ordering a school district to enroll a student at a particular school, a particular choice school under Georgia law. Okay, I agree that there is no law on that. The closest thing that we got is one where a student was expelled from an entire school system, and the court said, you know, no, that expulsion was wrong. You got to let them back into the school system. All right, that's the closest. That's the closest I think that we have. And then as far as, but I do think that we have some, again, persuasive authority. This is from the 11th Circuit saying, you know, and this was all cited in briefs that I've filed in the past, but just as a brief reminder, the CB versus Driscoll case, it's an 11th Circuit case from 1996, 82 F3D 383. You know, in footnote 4, it says, it is obvious, however, that Doe, the student, was not denied his right to a public education. He was only denied his request to attend the public school of his choice. Plaintiffs cite no Georgia authority, and we have found nothing indicating that the right to a public education encompasses a right to choose one's particular school. And the 11th Circuit was quoting, you know, a 10th Circuit case because they sort of imported that rule from the 10th Circuit, and of course all the other circuits have pretty much found the same thing. And then, you know, there's another 11th Circuit case. This court has never decided that a student has a property or liberty interest in attending a particular high school. And another one from the Northern District of Alabama saying plaintiffs has no constitutionally cognizable property or liberty interest in attending the individual school of their choice. So I do think that the case law that does exist out there about the issue of whether there's a clear legal right to attend a school of one's choice, I do think it's pretty clear that there is none. And I can't find one that says that there is. But to your question,
but the cases that you directed me to, aren't those alternative school cases, right? Where a student was kicked out of the school they were going to, and you could come back, but you had to go to this alternative school over here that they didn't want to.
Right, which actually then cuts in our favor because the plaintiffs in those schools were sent to a far inferior alternative school, whereas SC is in one of the best schools in the country. So I do think that if anything, that distinction cuts in our favor, not in SC's favor. And so, but otherwise, to your question about employment law cases, you know, I'll admit that I have not looked at that super closely to see exactly what the source of that right is. But I mean, at minimum, there are different processes that apply to employment action. So whether there, I mean, yeah, I guess if there's case law saying that a teacher is entitled, I mean, maybe there is a statute saying a teacher is entitled to return, you know, for a due process violation. They're allowed to go back. I don't know. If there's cases that say that, and which is what y'all say, that's fine. Okay, well then maybe that's clear for teachers. But obviously, teachers and students are completely different. And you know, the Board of Education is vested with a lot more discretion to decide what is in the best interests of students. And so, I mean, to the extent that there's any relevance there, and I can't really speak to that because I haven't really gone through all that. But I will say that certainly couldn't create a clear legal right for a student. You know, at best, I guess it could show a clear legal right for a teacher. But teachers and students are very different. And there's a lot of different you know, considerations, of course, that school officials would need to consider when deciding whether it makes sense for them to attend a particular school or return to a particular school. Also, I don't know if any of those, did any of those cases say that a teacher is let's say a teacher that was fired from Innovation Academy, does that teacher get to go back to Innovation Academy, or do they just get their job back in the school district and send them to Alpharetta High School? I mean, my guess is
I don't
probably
know
the
the
latter,
specific
right?
ins and outs of those cases either, Mr. Bryan, except I'm generally familiar with the way that Ms. Waldman is attempting to characterize its similarity here, which is that it's pretty well established in the case law that those teachers have a property interest in their continued employment and that they can be deprived of that property interest upon a showing of property process, which at the end of the day is really what this case is about. Is there an interest that SC had, and if in fact she had such an interest, what was the extent of due process that was required to be provided to her, and was it for that interest to be removed? That's why I asked, because I think I understood that to be how she was characterizing the similarity.
And fair enough, Your Honor. And I think that if we're going to go ahead and characterize it, then let's, then I'd like to be precise about that. If there, I mean, I don't know. I suppose in theory, if there's a rule that said a teacher has not only a right to employment if she wins a due process hearing, but she has a right to go back to exactly where she was, teaching the same classes and teaching in the same schools. And the school district has no authority to say, hey, you were teaching history before, but now you're going to teach English. Or you were teaching at Innovation Academy and now we're going to have you teach at Alpharetta High School. I don't know. Maybe those cases exist. I haven't seen any. I feel like that would be, I think that would be tough to rule on that if without providing some more notice. But in any event, even if it did say that, again, teachers are different than students, and to the extent that's persuasive, it cannot create a clear legal right. And that's what we're asking. That's what's required here. A clear legal right, not a maybe, not a 51%, not a we think it's likely. No, it has to be clear. And in almost every mandamus case in which I mean, I don't know if we'd be able to point to a mandamus case where it was granted based on sort of an amalgamation of rights that are pulled from from a bunch of different sources to amalgamate them to create a right. I would like to mention one thing to that regard. I know that we've talked a lot about, Miss Waldman, brought this up again in her arguments where she said that, we're within the last one, the last case, we're within this scope of 221160, and that's it. And in fact, actually, their brief cites a case that I wish I had noticed the first time around. That I don't know really cuts against that provision, that argument. And the case is In Re Cherie Baps Corporation. This is cited in the plaintiff's or in the petitioner's brief here. Let me go ahead and I want to make sure that I'm not mischaracterizing it in any way here. Sorry, I have like 1,000.
I can only imagine. I've got several myself. So I've got exhibits on one screen. I've got another tab with case law open. I understand, Mr. Bryan.
I do apologize here. I know that I have their brief up here somewhere. Okay, yeah, it's on page 17 of their brief. And they say that the argument is that even when the applicant seeks to engage in seemingly privileged activities such as selling liquor, courts will not allow a local municipality to cite their absolute discretion as the sole reason for the denial of a license. Now, of course, we've never made the argument that it's absolute discretion. We're just saying that there's no, abuse of discretion here, and my clients were simply complying with the law. But they cite a case in support of this, In Re Cherie Baps Corp. 346, Georgia Appellate 434. The denial of an applicant's liquor license without evidence warranted mandamus relief. And if you actually look at that case, the applicant's liquor license was denied. And then they appealed that through the writ of cert process. And they also asked for mandamus relief for, for issuance of that license, alongside a writ of cert, which of course is, one of the special statutory processes. And the court actually granted the mandamus relief, which I think really shows that it was that idea that if it was raised properly would have been within the scope of the previous case. But I'm going to go ahead and leave that there. I will also say that I do think the evidence shows that there is a lack of clear legal right here, and I think that the petition for writ of mandamus should be denied.
Thank you, Mr. Bryan. Ms. Waldman, it's your petition, so you get the last word.
Yes, Your Honor, thank you. I will do my very best to be brief. Let me start by this clear legal right concept. Mr. Bryan would have us believe that a clear legal right exists only when there is a statute that says if you do X, then Y happens. Quite frankly, if that were the case, we'd have no case law, because that's just not how the law works. Gilmer County v. City of East LJ, 272 Georgia 774, very clearly says you don't need a case or statute on point. Cases and statutes that create a right by necessary implication are sufficient, right? The concept behind mandamus is that a clear legal right can be created not just by statutes that says if X happens, Y happens, but by clear implication from the statutes, the case law, the processes, the procedures, and all of the above. We have a clear legal right. There was a due process violation, and a due process violation resulted in a deprivation of a property interest, and the remedy for that is the return to school. We have cited, I will not do it again, all of the cases that talk about mandamus being an appropriate remedy for a due process violation, including in the context of school cases, again, not school choice programs. The cases Mr. Bryan identifies in answer to your direct question were not directly applicable. They were cases that stand for the proposition that you don't generally have the right to a school choice. I don't disagree with him on that. I never have. If there wasn't a but-for reason for you not being in the program. The but-for cause is the illegal removal. If SC had never been accepted, had never been illegally removed, went through the student assignment process, and was not accepted, we wouldn't be here. If SC voluntarily said, you know what, Innovation Academy is not for me, I want to give Alpharetta a chance, and then changed her mind and wanted to come back, she absolutely does not have a right to do so. But none of those are what's at stake here. What's at stake here is an absolute deprivation of her property right, where the remedy is to go back. I'm going to go to one of those employment cases that I mentioned, which is Allen v. Autauga County Board of Education, 685 F. 2nd 1302, and that is in our brief. That is an employment case. It was a teacher case, and the issue there was whether the teacher got to come back. And the 11th Circuit in that case says this rule of presumptive reinstatement is justified by reason as well as precedent. When a person loses his job, it is at best disingenuous to say that money damages can suffice to make that person whole. The psychological benefits of work are intangible, yet they are real and cannot be ignored. Yet, and the rest of this is because the school district at that time, the Board of Education at that time, made the arguments that it's not in your best interest to come back because there's ill will, right? There's a lot of bad feelings. Yet, at the same time, there is a high probability that reinstatement will engender personal friction of one sort or another in almost every case in which public employee is discharged for a constitutionally infirm reason. Unless we are willing to withhold full relief from all or most successful plaintiffs in discharge cases, and we are not, we cannot allow actual or expected ill feeling alone to justify non-reinstatement. That's where we are. That is what is happening to SC. Mr. Bryant made a telling comment in his argument earlier. He said, IA has moved on. If only it were that easy for SC. She has not moved on. And Your Honor should not allow IA to get away with moving on at this time. Thank you.
Thank you. So I want to echo something that Mr. Bryan said a moment ago, which is that I appreciate everyone's efficiency. I appreciate everyone's agreement in terms of what could be agreed upon. We eventually got there, and I very much appreciate that. I want to mull this over, and so I'm not going to rule today. What I'm going to ask, though, is for both sides to submit to me a proposed order, one granting the writ and one denying the writ and dismissing the case. Mr. Bryan, I would like that. Today is Wednesday. If next Wednesday would be soon enough, if I could have it before then, that would be great. But obviously, I know you have other cases and other things to do. But if I could have it by Wednesday of next week, so that I can, and send them to Mr. Freehoff in Word format so that I can edit. I want to spend some time. I've read your briefs. I've read the exhibits. I want to spend some time with the case law in terms of the extent to which, Mr. Bryan, you've, continued to focus on the clarity or, the clear legal right that has to be established for mandamus, and how that plays into what interests Ms. SC had that could have been vindicated through this mandamus process in terms of her expectation and what right she had to attend not just a Fulton County school, but Innovation Academy. I will say that, to Ms. Waldman's point, the arguments I've heard about the due process that SC received as a part of the disciplinary process, to me, are not outcome determinative or really even relevant to my decision here, because that process clearly is provided, clearly exists, and is associated with any decision to take disciplinary action against the student. So I will also say that, to Ms. Waldman's point, there's absolutely no doubt in my mind that if SC was just a student who had never been admitted to Innovation Academy and had never attended Innovation Academy, she would have no interest, no right that could be vindicated here. Now, I'm not sure I agree fully with Ms. Waldman that she definitely did have a right once she was admitted. That's what I've got to struggle with. But I wanted to give you some insight. And the reason I point that out, Mr. Bryan, is because I think some of the school district's argument has been focused on the court improperly invading the purview of the school district to make those academic decisions about where students should attend and how things should be, what the application process is, how zones are drawn, who gets to go to innovation generally, those sorts of things. And I agree with you. That's outside my purview and not something that I should inject myself into or second guess in this context. But I'm not sure that's what we have here. And the question is, if we're outside of that, then what rights accrue, what responsibilities apply? And so that's what I'm going to struggle with. And so if you can take whatever that gobbledygook was that I just said and try to answer those issues for me in your proposed orders, it would be very helpful. Anything else that the parties need from me, Ms. Waldman?
No, Your Honor.
Mr. Bryan?
No, Your Honor.
Okay, thank you all very much. Have a good day.